But
Yes.
item number 56 in the supplementary list. So it was filed on Monday, and there has been a subsequent development yesterday for which a fresh petition has been filed today. So I just pray for your lordship's permission to do it at 2 along with the new matter.
Any urgency?
Urgency is that, my lord, I am asking for an interim order. I have been holding the charge, and yesterday evening, my lord, I have been relieved of the charges. The selection process is under challenge in item number 56. And yesterday, another order was passed, which challenging which, my lord, a fresh petition has been filed this morning.
All right.
So at 2, my lord.
May I please, Lordship? Lordship, item number 47. I have for the petitioner filed this IA, and eventually the matter already been infectious matter. The matter may be closed.
Your good name?
K. Bhuya.
Mr. K. Bhuya, learned counsel for the applicant. Submits that the matter has become infructuous and prays that the matter may be closed.
Lordship.
Anyone appearing for the other side?
Lordship.
In view of above, matter stands disposed of.
Oblations.
My lord, I am praying for
Matter
listing. this-
stands closed. Yes.
I am praying for granting a liberty, my lord, to move the unless motion, my lord.
Well,
Unless a motion, my lord, because my lord, perhaps some urgency. The petitioner before lordship was working as a principal of a high secondary school. His selection was put to challenge by another person, my lord. This honorable court directed the authority, my lord, to reconsider. On consideration, my lord, I was found to be the highest, top serial number 1. But my lord, I am retiring on 30th of this month. They are not appointing me, reappointing me as in principal again. As I am retiring on 30th, my lord, also kindly take up this matter today, my lord.
Have you filed it?
Yes, my lord, I have filed
Right.
it yesterday, my lord. I have filed it yesterday. my
All
lord.
right.
My lord, I have another prayer, my lord. The Steve Eggett petition, my lord, I filed on 14/11/2025.
What is that?
My Steve Eggett petition, my lord, under Article 226(3), my lord.
That will come tomorrow.
So
Steve.
that I have,
May I please, your lordship, my lord? My lord, I have prayer for listing of a contempt case, my lord. In what happened in this case, my lord? There was a specific direction from this honorable court, my lord, to provincialize the service of the petitioner within, my lord, 31st of March, my lord.
Is it,
Thereafter,
is it for motion?
is it for motion, my lord?
For motion?
Not motion, my lord, for admission, my lord.
Then you get it listed through the registry.
And then on Monday, my lord, next
No, no.
Monday. my lord.
Get it, go to the registry and get it listed. Yes,
Fine.
next.
May I please, Lordship, I pray for a listing of the matter, contempt application. Lordship was.
Motion.
No, my lord, admission.
If it's not motion, you
My
just
lord,
heard.
we have
what I think.
approached the, my lord, registry.
Please approach again. All right. Please
Sure.
approach again. There's a registrar maintained there also. You write enter the thing, case number there. They're accordingly listed, okay? Yes.
It be pleases you lordship. Your Honor, pertaining to item 42, your lordship, we are going to file affidavit in item number 40 and 41, your lordship. So your lordship, records may call for your lordship.
No, what do you mean? You're filing what?
Affidavit in opposition.
In item 40 and
Yes,
41?
your lordship.
When are you going to file?
40 and 41, your lordship.
When are you going to file?
Today itself, your lordship. So records
You
may
file
call
it,
for.
then
Your lordship, records will not come, your lordship. Records will not come, your lordship, because early morning today, your lordship will going to file it, your lordship.
you are going to file.
File, your lordship.
You have not filed.
Not yet.
So what is there to call if you have not filed?
Your lordship, today
You file
morning-
it, we'll list it
Yes,
some
your
other day. On behalf of which respondent?
lordship. Respondent one, your lordship, Pritam Sekia.
Ms. P. Das, learned counsel for respondent number 1 submits that affidavit in opposition is going to be filed during the course of the day
Consonants.
on behalf of respondent number 1. Not on behalf, by respondent number 1. Stop in view of above, let the matter be listed next week, any day. On 3/12,
Deeply obliged,
40, 41, 42.
deeply obliged.
May I please, your lordship?
Yes,
Lord, I beg to mention for listing a matter on Monday, my lord. the
motion.
mat- The matter,
Is it motion?
no, my lord.
If it's not motion, please approach the registry.
This matter has not been coming from 9 months.
All right. So you approach
This
the
has to
registry,
become after 4 weeks, man.
approach the registry.
Registry, my lord.
Hmm. Next.
May I please, your lordship? Lordship, similar prayer, I pray for listing of a read petition in admission stage, lordship. On last occasion, it was supposed to be listed after 1 week,
You
lordship.
have heard what I said. Don't repeat like that. Anyone else? You mention?
It's a new case I am paying for listing on Friday, man.
What is the urgency? Motion.
Most of my,
What is the urgency?
urgent, very urgent, my lord, but,
Tell me why, how it is very urgent.
because my lord,
Subject matter is very urgent.
yes, man. Kindly, my lord.
How can that be?
Last one, Friday.
Subject has to be something else. And why it's urgent, you tell me.
Regarding my lord, reinstatement of the petitioner. Service.
Huh?
Regarding reinstatement of the petitioner in the service, man.
Reinstatement is not an urgent matter. It'll come on due course. All right.
And on last Friday file, my lord, because my lord, they are delaying matter, my lord, new
When
matter.
did you file it?
Last Friday, my lord.
Last Friday?
Yes.
Today is what?
Today is my lord, Wednesday, my lord.
Wednesday. So only 3-4 days now.
Monday.
Where's the delay?
Friday, my lord. Kindly, my lord. Very urgent, my lord. Otherwise, I do not have my lord, pay, my lord.
Next Wednesday.
Hmm?
Wednesday next. 3/12.
Apply.
Hmm. Yes.
May I please explain? So far as item number 51 is concerned, my lord. There's some development is going on. I want to withdraw this case with liberty.
And what about 52?
Lordship, similarity.
Okay, learned counsels for the petitioners submit that some development is going on and therefore they would like to withdraw the writ petition. To stop, however, they pray that liberty may be granted, file afresh. In case the same is required. Anyone else? Appearing? No. In view of above, writ petition stands disposed of as withdrawn. Liberty is granted to file afresh. As prayed for. Yes.
May I please, Lordship? Contempt petition, my lords, orders page number 9 and direction from page number 11. We have furnished a copy of the order, my lord, which was duly received on 2nd of July 2025.
Your good name?
Lordship,
Your name?
P. Bora.
Heard Miss P. Bora, learned counsel for the petitioner, who submits that the order passed by this court on 25/6/2025 in WPC number 2836 of 2025 has not been complied with, despite a copy of the same having been furnished to the respondent. Next para, issue notice returnable by 3 weeks. Steps within 3 days. Yes.
Maybe. The contempt matter, my lord, regarding non-payment of area salary, this honorable court, my lord, directed to take action in the matter, my lord, within 2 months, my lord. Penalty made where parties, my lord, paid 17 months. And my lord, the order was passed long back, my lord, on 21/8/2024, my lord. And 2 months' time was granted, my lord. But
What was the direction?
direction, my lord, the parties, my lord, also kindly have a look, just the relevant portion, page.
16, paragraph 5. Please read.
Yes, ma'am. Paragraph, considering the short question involved in this writ petition is disposed of, directing the petitioners to make their individual representation before the director of elementary education Assam within a period of 2 months, 2 weeks from today. The director of elementary education Response number B shall thereafter consider the representation made by the petitioner and dispose of the same after verification of all the required documents by a speaking order in accordance with law within a period of 2 months from the date of receipt of the representation to be filed by the petitioner. Thereafter, my lord, the proposal was taken by the director, my lord.
No. You tell me first, when did you file your representation?
My lord, immediately thereafter, passed, my lord, and lordship, this is the communication I am relying on, my lord, page 18, my lord.
I know, but tell me, when did you file the representation?
My lord, it was filed immediately thereafter, my lord.
Where is your statement to that effect?
My lord, paragraph, my lord, 7, my lord.
Read.
Accordingly, the petitioner submitted the said order of this honorable court to the director of investigation Assam. Thereafter, director sought proposal for.
No. This is just here and there. Don't hodgepodge your facts.
Yes, ma'am.
You have not complied with the court's direction.
No, no, this is thereafter, my lord, they took step, my lord, in reference to our high court's order. Lordship, kindly will page 18.
Please write down. Mr. A.M. Borbuya, learned counsel for the petitioner, shall file an additional affidavit specifically indicating as to when the representation was filed by the petitioner before the authority concerned. You file affidavit, we'll see. And for which a week's time is granted. List again on so and so.
My lord.
One additional
My
affidavit.
lord,
Please give me the facts.
oblige.
Your lordship, from our part, your lordship, a file has sent for approval of finance department, your lordship. They have to make the finance as your lordship responded, your lordship. Already they have not implemented finance department in the writ petition. So we have already moved it on 4/11/2025, your lordship.
What did you move? What have you moved?
For the approval from finance department.
Yes, madam, what is the matter?
See the last order, lordship.
What is the matter?
Lordship, matter relates to the compassionate appointment, lordship. His name was duly recommended by the SLC and thereafter, lordship, kindly see the last annexer, annexer 6, page 48, lordship.
Page 48.
Yes, lordship. This is the letter issued by the Director of Secondary Education. However, lordship, the file was sent to the Department of School Education, secretary to the Department of School Education. So last para, lordship, it was stated that Bindusar Kaisok, that is the petitioner, to be appointed on compassionate ground as per the recommendation of the SLC, lordship. And this order was passed on 21/12/2023, lordship. Now, lordship, it is year 2025, lordship. 2 years elapsed, lordship. And they have taken time, lordship.
They have to make a finance.
Lordship, the order is given by the director.
Just a minute.
Finance department is not necessary party, lordship.
This letter is from the director to the secretary.
Yes, lordship. For
And what is
giving the
this?
Approval, lordship.
As
Huh?
per,
For
as-
giving the approval, lordship.
Now, what is this reference here?
Reference is, lordship.
Government letter number so and so, dated so and so.
Yes. Kindly see the letter issued by the inspector of school, lordship. That is annexure 5, page 40, lordship. After receiving the recommendation, lordship, the post was already created and accordingly SIU format original post creation order copy and permanent retention order was forwarded to the director, lordship. And after receiving this said, director has forwarded to the secretary for approval.
No, this is from the inspector of schools to the director,
Yes, Lord.
then from the director to the secretary.
Yes.
Now, where is the minutes of the SLC which
Yes.
recommended?
That is annexed, Lord. Annex 3, Lordship, relevant portion is page 33. 33, Lord. Petitioner name is appeared in serial number 14, Lordship. Yes. And last column, Lordship, eligible for appointment, but due to lack of vacancy under IS Lakhimpur, the committee recommended an adjusted grade 4 post under IS Tinsukia, Lordship.
Okay, this SLC minutes is dated.
Dated 2/3/2023.
Where do you get the date?
Also in the top of the minutes, Annex 3. Annex 3, page 25. Two, 3/20.
So the SLC recommended, but due to there's no vacancy, so they say that it should be adjusted against the grade 4 post in under IS Tinsukia.
Yes, Lordship.
Then what happened?
Then Lordship, the inspector has adjusted his post in Soikwa Hindi High School, Lordship.
Hmm?
Soikwa Hindi High School under IS Tinsukia. That is 41 page. This is inspector of school prepared a checklist to be filled up and signed by the secretary commissioner of administrative for
Page
examination.
41.
Page 41. Location of the post, Soikwa Hindi High School.
So post was located.
Yes, Lord.
Then
Then Lordship, this is the pro forma of SIU department, next page 42. This is type copy. Original copy is page 43.
now what is this 42?
This is a staff inspection report, Lordship.
Okay.
Grade 4.
Judicial department to Yes.
What is relevant here in 42?
So page 42 is this post was grade 4. This is the government post creation date and number, last retention, and cause and date of vacancies, Lordship. The original incumbent resigned, Lordship. And whether the post creation order and retention that is available. Next page, Lordship, report for strand detail. The grade 4, Lordship.
Opinions to
Where?
Next is 44.
Yes, what is 44?
12, grade 4 post, non-gazetted, sanction number and sanction date. Everything was mentioned. Lord.
So now what is to be done?
Your Lordship, pertaining to that, Your Lordship, the file has already placed before the department, judicial department. And the file has already received by that department, Your Lordship. And judicial department was represented by GA Assam.
Hmm.
So they are the proper authority, Your Lordship, to provide the present status of this case, Your Lordship. Pertaining to that, Your Lordship, a detailed report was made. Your Lordship, I would like to place it. এখন Government of Assam may be given direction, Your Lordship, to bring the present status of this case, Your Lordship. Already file has before in front of them, Your Lordship. It was under process. And judicial department has received it and it is under process.
So the file has been received back from the judicial department.
Yes, your lordship.
It is lying with your department only.
No, GA Assam, Government of Assam, your lordship.
no.
Already-
So kindly see the last order.
No,
Lordship.
just a minute.
Go back.
I am directed to inform you that the concerned file on the instant matter, which was endorsed to the judicial department, has been received by the department.
And the same is under process.
Received by whom? Received by whom?
Lordship, second page, your lordship, third paragraph, your lordship onwards. Your lordship, hence this department onwards. Hence, this department moved the matter to personnel department on 29/11/2024 for views. Personnel department returned the file, your lordship, on dated 24/4/2025 with a view to take suggestion from the judicial department. And thereafter, this department moved to file to judicial department on
From where are you reading?
second paragraph, your lordship, second page, your lordship. Second page, your lordship, third
Second
paragraph.
place, you read the third last paragraph. Thereafter, this department.
Thereafter, this department move the file to judicial department on 19/5/2025. The matter is still processed in judicial department.
Then, after that,
After this view,
soon,
department and this department will take necessary.
what
Your
is that?
lordship, after receiving judicial department views, your lordship, the department will do accordingly. So that report is, I am not aware, your lordship, judicial report, department views report.
No, what you should be aware of is whether you have received back report from the judicial department or not. Have you received back or not? This letter was written in the month of September.
September,
Now we are in November.
November.
So you find out whether you have received back the letter from the judicial department or not, and let inform
Or
the
any
court.
views received by
Ah.
the
No, Lordship, on the last occasion, they have produced a letter dated 4/11/25. However, it was stated that
তোমারে ভালো হবে।
on receipt of the SIU approval from the finance department of school education will take further necessary action, Lordship. They have received the file already from the judicial department, Lordship, and sent to the finance department.
Okay, yes.
Now, your lordship, that is already, in the very beginning, I submitted that, that file has already been submitted to finance department. And now finance is the proper authority, your lordship, to bring the status of the present case. And they had not made any party to finance department.
Not required. You inform us, what information you have received from finance department. Ms. P. Das, please write. Ms. P. Das, Learned Standing Council, Secondary Education Department, submits that the matter was endorsed to the Law Department for their views. And after the views of the Law Department was received back, the matter has been endorsed to the Finance Department for concurrence on 27/10/2025. And the same is being awaited as on today. Stop. In this connection, the Learned Council has produced communication dated 4/11/2025, written by the Joint Secretary to the Government of Assam, Department of School Education. So, since more than 3 weeks have lapsed since 4/11/2025, Ms. P. Das shall obtain up to date status of the matter by the next date. Next week, Wednesday?
2 weeks time maybe.
No, no, no,
Oh, no.
just get the information, that's all.
Yes, sir.
Date may be fixed.
List again on Wednesday next.
All right.
I'm deeply obliged.
Lordship, in this matter, we were asked to get the records. We are awaiting the records, my lord. We have written to the department. Some time may be given to us, my lord. Will be a week's time, my lord.
Records will come from where?
Department, my lord.
Kindly pardon.
Department. On the last occasion, we had submitted this, my lord, regarding the extension, my lord. And your lordship perhaps had asked for the records.
No,
from the
I
council,
remember,
previous
I
council.
remember. This is the same thing which you have produced last time.
Yes,
Yes.
my lord. So that is the last.
Now, this
communication.
order was passed on 21st of November,
My lord, my lord.
correct?
Yes, sir.
Last Friday.
Right.
You were supposed to get the records by today.
There was some, my lord, issue, my lord. There was some issue, my lord, so the department
can you
has
produce it?
requested, my lord. My lord, in the next week, my lord.
Monday,
Probably, my lord,
Monday.
Wednesday, man.
Monday.
Wednesday, man, will be.
You produce it, otherwise we'll have to ask somebody to come to bring it personally.
My lord, then my lord, Monday, my lord, I'll try, man.
Uh, although the Learned Standing Council Elementary Education Department was asked to produce the original records with regard to the suspension of the petitioner.
Review of suspension.
And review thereof. Right order dated 4/10/2025. Stop Learned Standing Council, Mr. A. Fukan. Place for further time. Considering the submission made. Let this matter be listed on Monday,
Monday, man. I'll ensure, my lord. I'm appearing, man, first time today, man.
on 1/12. On which date the record should positively
Right,
be
right.
produced.
Obliged.
Matter relates to the MPS and OPS, Lordship. Petitioners, some of the petitioners already retired, Lordship, and some are on verge of retirement, Lordship. Petitioners are now providing the new pension scheme, Lordship. Though, Lordship, state government had introduced a scheme, Lordship. Kindly see page 140, Lordship. They have introduced that those the employee who have appointed after 2025, but their recruitment started before 2025, they will get the old pension scheme, Lordship. Petitioners also similar, Lordship. They have appointed much before 2005, Lordship, but their service has been provincialized after 2005, Lordship. But they are not considering in the under
Oh.
this scheme, Lordship.
Where's the scheme?
Lordship, page 140, Lordship, kindly see, this is the initial order of the finance department.
1/14.
140, Lordship, and exam 4. This is the type copy, vernacular copy, page 140, Lordship. 140, this is the vernacular copy. There is a findings, Lordship, in this regard, in this notification, Lordship. Findings as well. Findings, Lordship, in the middle portion, Lordship, of this notification. Vernacular copy, page
I
140,
notice it.
Lordship. Thereafter, one minutes of the meeting, Lordship, of the Chief Minister of Assam as well as some Karmachari Parishad, Lordship, the petitioners also members of the said Karmachari Parishad. There is a minutes, Lordship, decision number 1 also there in page 142, Lordship. Initial appointment petitioner were appointed in a bencher stage lordship. That their service has been
প্রভিন্সিয়ালাইজেশন হওয়া নাছিলে সেইকাৰণে নতুন পেঞ্চনৰ আমাকে
পিটিশন আসছে, চেক করাই দিন। বহুত কেটা করে।
সিমিলার ম্যাটার আছে
না,
Sure.
This page 140 is passed pursuant to some direction of the court.
Lordship.
Manoranjan Basumatari.
In this regard, Lordship, the earlier Lordship, some of the similar situated person approached the honorable court, whereas when the appeal was decided, Lordship, the state government produced.
Mr. Counsel, please sum up your case. I'm not able to understand what you're saying.
Kindly see one page 42, Lordship.
Please be clear about your submission. What exactly do you want?
Our prayer, Lordship, we want to hold pension scheme, Lordship.
Who are you?
Pursuant to this notification, this order.
Who are you? Who are you?
We are the teachers of the, and as well as some other staff of the schools, Lordship. Initially, our schools were venture, Lordship. Subsequently, our school in the year 2013, Lordship, our service has been provincialized by the state of Assam, Lordship.
2013.
2013.
When were you appointed?
Appointed before 2005, Lordship, one, annexure one, Lordship, my one,
And provincialized
2013, Lordship.
in 2013, your services.
This is our services, Lordship.
So,
So our claim is that, Lordship, though similarly situated person pursuant this order, as well as the minutes of the state government, Lordship, they are going to be provided the old pension scheme, Lordship.
who are those persons?
In the other department, Lordship, those who have appointed after 2005, but recruitment was started before 2005. Like us, Lordship. Our recruitment has started much before 2005, Lordship.
Okay, who are those persons?
But they were not provincialized.
Pursuant to this notification, Lordship,
What?
kindly see the.
Provincialization order to.
No,
be
just
done.
point out who are those persons. Do you have annexed one judgment here?
I said it.
Dilip Kumar Mehdi and others.
Judgment, Lordship, related to our Lordship. When our service was not provincialized, Lordship, some of the petition, some of the similar situated person approached this honorable court for provincialization of the service.
Then,
In these judgments also clearly stated that, Lordship, this honorable court observed that
that was regarding provincialization.
provincialization,
Today, you're asking for all pension.
old pension.
On what basis?
Pursuant to this order, Lordship, page.
Which order?
140, Lordship.
Huh?
Page 140.
This 140 is passed in respect of whom?
In respect of the those appointed before 2000, after 2005, but their recruitment process was started before 2005.
That I know, Mr. Counsel. I'm asking you, who are those individuals?
All.
Where?
Employees
Who?
of the state go under the state government.
Who? Are they the writ appellants?
No, Lordship.
Then,
This
this
is
order was passed in favor of whom?
in favor of all the employees, Lordship.
Please
those who
identify
are-
them. Who are they? Show me. Who are they?
No particular employee, Lordship, all the employees under all departments of the state government.
Please look at the order,
Lordship.
140. Please look at it carefully. It speaks about one writ appeal.
One readable, Lordship.
Is it in respect of these people?
No, Lordship,
Then?
it's not petitioners, Lordship. Is writ appeal, Lordship, related to this similar situated person earlier approached this honorable court when this appeal was under hearing, Lordship, before this honorable court, Lordship, that the state government produced these some documents that we are going to be introduced one scheme, those who have appointed before 2005. But 2000, after 2005, but their recruitment has started before 2005. In this observation, Lordship, this readable was closed, Lordship, by this honorable court. Kindly see, Lordship, another annexure is there, Lordship, 143, annexure 6, Lordship. Now, Lord, state government collecting the data from the employees who are appointed before, after 2005, but their recruitment is started before 2005, Lordship. We are not covering under
Recruitment process started before two thousand
This is
five,
the main issue, Lordship.
provincialized later on, and you are relying upon this order, 9 January 2025.
Some of the similar situated person.
Then you go and approach the respondents, file representation,
Similar to read petitions also pending before the honorable court in this.
file your
regard.
representation saying that we are also covered, give us the benefit, then you come back.
Our representation, Lordship, indicates in the annexure 6, page 143, Lordship.
Representation, होगा sir.
Representation is not annexed, but representation, Lordship, our demand, Lordship.
Make a demand.
In mentioned in the 143, page number 143, Lordship, kindly see, Lordship.
What is 143?
143 regarding our, this demand, Lordship, particular regarding old pensions.
Your lordship, particularly did, this petitioner has not make any representation before the authority.
Not
Oh, that-
personally, we have.
That is what I'm asking, Ms. P. Das, you take your seat. Don't second what I'm saying.
We-
143, what is this?
We have a one society, Lordship. So those are Kormachari.
No, no, no. Just a minute. Where is your representation? 143 is not your representation.
Not my representation, Lordship, but
Then-
our,
If you have not filed representation, file now. Then you come back. Not
we
like
have
this.
already approved, Lordship, in this regard. This is mentioned.
No,
in
no,
the
no, no.
143, Lordship, kindly see.
Your statement at paragraph 22 of the writ petition.
We are the member of this society, Lordship, Kormachari Porishad.
Please read the statement. 22, paragraph.
Yes, Lordship, we have demanded justice.
Where? Where have you demanded justice?
Since last 1 year, Lordship, we are.
Show me in black and white.
Particular representation, I have not annexed, Lordship.
You have not submitted.
We have submitted, Lordship. We
Then
have
why didn't you
submitted,
annex it?
Lordship.
Then why didn't you annex it?
Our delegates, Lordship, already sit with the state government, Lordship. The minutes itself, it is mentioned, Lordship. Kindly see the minutes again, Lordship. The headline of the minutes page 142, Lordship. This is the chairmanship of Chief Minister Assam in connection with the various demand of Shaddo Assam Kormachari Porishad. We are the members of the Kormachari Porishad, Lordship.
Where?
Lordship, 142, the headline, Lordship. This is the
Headline.
above, Lordship. Actionable points of the branches directors of finance
yes, sir.
department on the minutes of the meeting held on 11/1/2025 under the chairmanship of the Chief Minister Assam in connection with various demands of Shaddo Assam Kormachari Porishad, Lordship.
Who are these?
This is Shaddo Assam Kormachari Porishad is our society, Lordship. We are under this society, Lordship. This is the employee
Society is not before this court.
No, Lordship.
Society has not come before this
We
court.
have approached
This
government.
writ petition is filed by society.
Not, Lordship.
Then
Personally, we have.
just because you are members of that society, you're saying that you have approached.
Approaching this honorable court, Lord, in this regard, various petitions, Lordship, pending before this honorable court. Kindly, see, Lordship, this is the.
What are the various writ petitions?
No, he is referring to this. What is issue?
This is issue.
Higher education. I'll cut a representation to people by Martin.
So we'll tag it with this case. Hard, Mr.
ABT hope.
ABT Hawk, Learned Counsel for the petitioners. Issue notice of motion returnable by 4 weeks. Ms. P. Das, Learned Standing Counsel.
I'm appearing for respondent
Secondary
1,
education.
3, and 5.
Yes, for respondent numbers 1, 3, and 5.
Lordship, I
Say Chalia for respondent number 2. This is elementary.
I am appearing for secondary. Elementary is also party here. Right. Similar.
Ms. S. Sutia, Learned Study Council Elementary,
Oh,
for responding numbers.
same school name? Beleg beleg.
বহুত স্কুল আছে এটা সিঙ্গল স্কুল নহয় না
Different schools approaching your lordship.
4.
Beleg beleg school আছে.
Extra copies within 3 days.
Beleg beleg common.
List after 4 weeks along with WPC number 6579 of 2025.
Lordship, one observation, maybe tendency of this repetition
No,
shall
Your
not be a bar, Lordship. Otherwise, we have already approved,
No.
Lordship, if they
Lordship,
trying to consider, Lordship.
these issues were addressed in the judgment of Purnima Hore, Lordship, where all recruitment had started before 2005. The appointments was provincialized after 2005. And in that judgment, Lordship, it has been clearly decided that only the teachers who have been appointed on stipendary basis, they will be given the benefit of old pension scheme. That is under challenge on their.
But only tendency of the repetition shall not be a bar, Lordship. This is not interim order also, Lordship, if department consider, Lordship.
May I plead your lordship? The petitioner before your lordship, he was a grade 4 employee. After 30 years of his service, he retired. But during his period of service, he was not promoted. So the government of Assam has a scheme that in every 10 years, one increment will be given. As per that, this 45 of that scheme, and it's just 6. But he has not been given only one SCPS, but 2 increment was not given. Then he filed representations, and that representation is pending, nothing has happened. This 45 is the scheme.
Yes.
And
Ad hoc Learned Counsel for the petitioner, who submits that by filing this writ petition, the petitioner has sought for a direction to the respondent authorities concerned to reach the financial benefit entitled to him under the modified assured career progression scheme, which has been denied to him. Issue notice of motion. Term of 4 weeks. Speed us.
I'm
What?
appearing for 1, 3 and 4.
Respondent was 1, 3 and 4. Ms. S. Chaliha for respondent number 2. Extra copies within 3 days.
PDF that I will be. Deeply abused.
May please. Lordship. The method relates to my lord, non-release of pension and other retirement benefits, my lord. The petitioner retired from service on 26/11/2021 as an assistant teacher of LP schools, my lord. My lord, the facts of the case is that, my lord, the petitioner was appointed on 19/12/89, my lord. And thereafter, my lord, one show cause notice was issued, and the petitioner replied to that show cause notice. And finally, my lord, on 18/5/1992, the service of the petitioner was terminated, my lord. The petitioner approached before this honorable court, my lord, in the, my lord, CR number 617 of 1993, my lord. And this honorable court was pleased to, my lord, was the termination order and directed to reinstate the petitioner. The petitioner, my lord, while in service, the petitioner was allowed to, my lord, undergo the Assam Junior Basics Training course, my lord, and she has completed, and thereafter she received salary. But again, my lord, from September 2007, my lord, salary of the petitioner has been stopped, my lord. Again, the petitioner approached before this honorable court, my lord, and this honorable court directed the respondent authorities to release their salary. And subsequently, the contempt applications also filed. The same is still pending, my lord. And the salary up to, my lord, June 2014, they have released, my lord. But subsequently, my lord, they have accommodated me as tutor in the year, my lord, 2021. And I have retired from service, my lord, on 26/11/2021. There is a, my lord, condition stipulated in my accommodation order in 2021 that I cannot claim, my lord, past benefits. That is, my lord, under challenge in this present litigation.
Page number?
The, my lord, accommodation order, my lord?
Yes, as tutor.
Yes. That,
That you're challenging now.
yes,
Page number?
that,
62 and 61.
61.
61 looks like 62.
No, my lord, it is, 58. 58.
Huh? Next are 6, isn't it?
Type copy. Type copy.
The next are 6.
Yes, my
Next
lord,
is-
NSXC, type copy is 58, my lord.
5 copies 58.
Condition clerkship will find page 59, second paragraph. The original photocopy, my lord, at page 61. Page 59, second paragraph is the condition.
Will issue notice.
My,
Art Mr.
are sort of.
R. Sharma, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the order dated 31/2021, bracket annexure 6, by which his service has been adjusted as tutor and he has been denied of his past service rendered as what?
As assistant teacher of LP school, my lord.
Past service rendered as assistant teacher of LP school. And further, the benefit of pension has also been denied to him. Next, para issue notice of motion returning for 4 weeks. Says Sukiel and its standing council, elementary education accepts notice on behalf of respondent numbers
1 to 5 minutes.
1 to 5. Anybody else is there?
For 6B, Sharma.
Mr. B. Sharma accepts notice on behalf of respondent number 6.
I'm paying for respondent number 8.
Mr. A. Chaliha for respondent number 8 and Ms. N. Pukan. Or Mr. D. Diori for respondent number 7. Notice is complete, extra copies within 3 days.
My lord, in the meantime, my lord, my GPF amount may be directed to be released because, my lord, the GPF amount is deducted from my salary during my service period. They cannot, my lord, withhold that part, my lord.
Yes.
Before
GPF,
that, my lord, some time may be granted to take instruction.
Because GPF is my amount, my lord. It cannot be, my lord, withheld, my lord.
If the petitioner is seeking for any interim relief, my lord, then I may be allowed some time to take instruction.
okay, next para, right, the learned counsel for the petitioner phrased for an interim direction that the GPF amount should be released to him. And the same cannot be withheld by the respondents. Ms. S. Sukiel, learned standing counsel, elementary education shall obtain instruction in this regard by the next day. List on so and so. Not next year. We'll have it this December, anytime.
My lord, interim order will be considered. my
No, no, list on 12/12 for consideration of the interim plan.
lord.
The petitioner is an assistant teacher in an elementary school, and this is with regard to non-payment of his area incremental benefits. Now, that amount is reflected in a proposal at page 29.
No, your writ petitions for what?
For seeking payment of his area incremental benefits for a particular period. If your lordship comes to page number 29,
Just a minute, area incremental benefits. With effect from,
from 1998 to 2019.
What is this order dated 29/6/19?
My lord, that particular, I'm entitled to that particular order, to that particular amount based on a order
Order.
passed by this court.
Where is that?
But before that, lordship, my lord, this is a covert case. I may take your lordship to the judgment which by which I am covered.
This 29/6/19?
No, my lord, in my instant application, it's that issue is covered, my lord. Similar applications have been allowed by this court. That your lordship would find at page 30. Page 30, my. A bunch of read petitions with similar prayer was allowed by order dated 4/3/2024. It starts at page 36.
Mhm.
Page 37, para 3, if I may read.
Yes.
The petitioners are working as assistant teachers in their respective schools pursuant to the orders passed by this court in WPC 3058 of 2011 by the judgment and order dated 19/5/2015. A decision was taken by the respective departments by the order dated 29/6/2019, whereby the petitioners were regularized in service with effect from 24/4/1998 and payment of regular salary as per pay scale prior to 2/8/2010, along with other consequential benefits as admissible for all practical purposes, including pension under the relevant provisions of the Act in force. Similar orders have been passed by the competent authorities in respect of all the petitioners. The petitioners are now aggrieved by the incremental benefits which have been denied to them, notwithstanding the payment of regular salary. These incremental benefits are payable to them as the same have already been released to other similarly situated teachers. In this connection, learned counsel for the petitioner has referred to a communication dated 4/1/21, whereby the district elementary education officer has sent a proposal to the director of elementary education for release of the area salary, showing the amount payable to the respective writ petitioners. Insofar as the writ petitioner in WPC so-and-so is concerned, his name appears as serial number 3. This position is not disputed by the respondents. However, in spite of this communication forwarded by DEO Nagaon, reflecting the amounts to be paid in respect of the teachers, the amounts have not been released to the petitioners. Notice have been issued in all the writ petitions. However, no response is forthcoming from the respondents in spite of the opportunities being granted. Under such circumstances, this court is of the view that when the concerned DEO has already put up a proposal for release of the area incremental benefits showing the amount due in respect of the petitioners, and the matter is presently pending before the Director of Elementary Education or Secondary Education Department, as the case may be, this court is of the view that these writ petitions can be closed with a specific direction to the respondent authorities, more particularly the Director of Elementary Education or Secondary Education Department, to expeditiously verify and consider the claims of the petitioners in respect of the area incremental dues, and upon due verification, if the same is found to be in due to the petitioner, the same should be released. And that is my simple prayer. Let them verify and pay. And with regard to this particular bunch of writ petitions, my lord, I represented them, and as on date, all of them has received the amount. Yes, the instant case is based on a single writ petition. This proposal
Included
is a,
petitioner and the amount has been quantified at 11 lakhs.
yes, my lord.
Now,
that-
tell me, what is this order dated 29/6?
My lord. My lord, that your lordship would find at page 26. This is an order passed by the Commissioner and Secretary to the Government of Assam Elementary Education Department.
In whose case?
My lord, this is in compliance of a High Court's direction in WPC 3058 of 2011.
Yes, whose case was that?
My lord, that was a case filed by Association All Assam Operation Blackboard 4040. There,
Okay.
the challenge was made with respect to payment of area salary and increments.
So this amount which you have worked out,
My lord, the proposal I have annexed, my lord, at page 29.
no, this is regarding what, you're getting a fixed pay otherwise.
Currently, I have received all my area salaries. I am receiving my regular salary, and this is with regard to area incremental benefits.
No, it's your pay is scale pay,
My lord,
not fixed.
no,
You're getting scale pay.
regular scheme.
Then how come this is area?
Because as per that particular judgment and the order of the commissioner,
Hmm.
I am entitled to my area salary and incremental benefits from 1998. So that the area salaries were released, but this got left out. So the proposal has now been sent, and since they are not acting upon it, my only prayer is to let them verify and pay. That is all.
No, area is on the increment.
Yes. Because the area salary I have received.
Area salary you have received, but
Yes.
that increment area is not there.
Yes, yes. If your lordship would kindly peruse to the page 29 once, man, the proposal.
Who has made this?
This is by, this is prepared by the headmaster of that particular school and countersigned by the Director of Elementary Education. Statement showing the required information year-wise as per Finance Department's letter so-and-so for area salaries in respect of Hussein Ali Ahmed. There it is shown, madam, the period is shown 24/4/1998 to 29/2/2019. And the amount is also reflected, 11,92,000 something like.
Yes,
Can we notice maybe issued, madam? Area incremental for almost 21 years, so we have to verify, madam. So can you notice maybe issued,
can
madam?
it not be disposed of by giving you liberty to verify and make the payment if
That
it
is
is
what-
found to be correct?
That is
That
my
much
sug-
only.
Because the covert case which I have shown, your lordship, that is the same relief which I have been granted, and pursuant to it, I have received the amount. And there it is also specified in that particular judgment that if found, after verification, I am found not to be entitled to that amount.
Okay, we'll dispose it of.
Well-
I'll record your submission.
Yes.
Heard Mr. P. Bhardwaj, learned counsel for the petitioner, and Ms. S. Pukan for the elementary education. Who else is there?
Only at elementary education.
Having regard to the nature of the grievance projected by the petitioner, the writ petitions taken up for disposal at this stage. Stop. By filing this writ petition, the petitioner prays for payment of rupees 11,92,199, which is in respect of the aerial incremental benefits due to him for the period with effect from the date of his regularization, that is 24/4/1998 to 29/2/2019. Stop. Mr. P. Bhardwaj, learned counsel, submits that in fact, the headmaster of the school concerned had worked out the amount due to the petitioner, and the same has been duly countersigned by the Deputy Inspector of Schools, Nagaon, as well as the District Elementary Education Officer, Nagaon. Stop. He further submits that a similar writ petition was filed. Similar writ petitions was filed by similar situated persons, and the lead case being WPC number 115. WPC number 15 of 2022. And this court provide order dated 4/3/2024 disposed of the writ petitions by common order by directing the respondent authorities concerned to examine and verify the claim for payment of the aerial incremental dues of the petitioners. And upon such verification, if the amount was found to be due, to release the same to them expeditiously within a time frame. So Mr. P. Bhardwaj, learned counsel, submits that he was representing the petitioners in that case, and in fact, all the petitioners have received their dues as on date. He therefore submits that the present petition, being similar to the referred petitions, the same may be disposed of in a similar manner. Next para to the above submission of Mr. P. Bhardwaj, Ms. Phukan, learned standing counsel, elementary education, submits that she may be given some time to obtain instructions in this regard. However, upon perusal of the materials available on record, it appears that the case of the petitioner is also similar to the referred writ petitions. And since the respondents are required to exercise the process of verification upon the claims, this court does not find any difficulty to dispose of the writ petition at this stage. Accordingly, the writ petition is disposed of by directing the respondent authorities concerned, more particularly respondent numbers 2, respondent number 2, to look into the claim of the petitioner and verify as to whether the amount of rupees 1192,199 as worked out by the principal of the school and countersigned by the Deputy Inspector of Schools and the District Elementary Education Officer of Nagaon are due to the petitioner. If the same is found to be true and correct, the same shall be released without further delay. The entire exercise be carried out within a period of
Here it was granted 3 months time.
same 90 days from the date of receipt of a certified copy of this order.
Obliged.
This matter relates to provincial election service. The petitioner are the assistant teachers of the schools, and their staffs, their schools were provincialized, but the petitioner's name were there because there is a spelling mistake in their names. Then, my lord, after corrections, my lord, fresh proposal was sent to the government, and it was placed before the district scrutiny committee also. And district scrutiny committee re-verified, that is page 30, annexure 5. Then again, my lord, it was verified by the independent authority. And then ultimately the director has prepared a views, that is page 33, and it is sent to the government, but nothing has been done till date. It was on 30/12/2024. This report was sent to the government for provincialization, but still nothing has been done. Your lordship, kindly see page 33, a relevant portion, page 34. And serial number 3 and 4, the petitioners. The details has been mentioned, so why their services were not provincialized earlier. In column 6, reason for not provincialized earlier, it is written that due to spelling mistakes of the name of so-and-so instead of so-and-so. Now, in column 7. after
No, just a
corrected-
minute, just a minute.
My
How many petitioners are there?
petitioners are 3 petitioners.
Where are their names?
Now 3, 4 and 5 serial number 3, 4 and 5.
3. Page 34.
Page 34.
Serial number 3 is
Three.
page,
3, 4, 5.
serial number 3 is petition number 1.
Mine.
Or
No,
what?
it is petitioner number.
Petitioner number 1 is serial number 5, page number 35.
Serial number 5.
5.
What is his name?
Petition. The serial number 3 is petitioner number 2.
No, what is the name of petitioner number 1?
Nalini Lakar.
This is P1. Then P2,
Abdul
Mr.
Wahab.
Abdul Wahab, that is serial number 3. My
Then number 4 is P3.
Musharraf Hussain is 3.
What is the remarks?
Remarks, my lord, this may be considered for provincial elections. After details inquiry, my lord, this case scrutiny committee also recommended an independent authority that is reflected in this, my lord.
What is
reviews.
the remarks?
That is, my lord, may be considered for provincial elections.
Where is that?
Column 10. In first 34 page. After correction of name, this office obtained UDIS report in column 7.
Where is the column which recorded the error?
My
Happened?
that is, my lord, from top, it is 6. Reason for not provincialization earlier.
Oh. Yes, due
Due
to
to
spelling mistake.
of the name. And 7, next, my lord, after correction of that, this office obtained UDIS report in respect of so-and-so, and it has been found that his name reflects in UDIS. Next, my on examination of independent authority report and UDIS report, he is found eligible as per provision of the Provincialization Act and may be considered for provision last. And this report was sent in December 2024 to the government.
What about petition number 1?
Petition number, next page, page number, next page, page 35. Same remarks.
It's not same.
No, so here is only enrollment deficiencies there. Enrollment report was shown earlier 8. The minimum enrollment required is 10 for provincial of service as per Provincialization Act. Now, next.
Yes, what do you say, Mr. Sharma?
My lord, in this statement, my lord, notice may be issued. In the meantime, I will take the instruction on the regarding that, my lord.
All right.
Well, the date may be fixed because, my lord, it is a similarly situated person. Our staff already been provincialized. My staff and other teachers have already been provincial in 2021. And we are and pendency may not be a bar for provincialization because already recommendation is pending before the secretary. Ad hoc. One date. Date is last page 23/12/2024. Last page 23/12/2024.
33.
No, there is.
He is there.
In this view in statement, it is last minor, page 38.
That I've seen, Mr. Council.
My.
My specific question was regarding page 33.
Mine, no need.
Why are you taking me forcefully to page
Because it is
38?
covering letter, that is why.
Covering letter should have a date.
Minor, that is not there.
Signature is also not there.
This correct. I'm not.
So whether this document is genuine or not, how do we know?
They may verify it, my lord. It is their document,
Why should we not dismiss your writ petition on that ground?
my lord.
You're filing writ petition for verification only.
No, no, no,
You have to assert your right.
that is correct.
I have a right because of this document.
But
And the document you show me does not have any signature,
that is,
no date. What did I say? Bracket annexure 7. Wherein at the end of the statements, it is, the same is dated 23/12/2024. Stop. The Learned Council submits that the services of the petitioners could not be provincialized at the relevant time along with similarly situated persons on account of certain spelling mistakes in their names and also on account of the report which wrongly showed the enrollment as 8 instead of 10 in the school concerned. However, the same has been rectified in terms of the report of the independent authorities, and therefore the petitioners are entitled to be provincialized in their service. Next parent, view of above, issue notice of motion returnable by 3 weeks. Mr. U. Sharma, Learned Studying Council. Secondary education. Accept notice on behalf of respondent numbers 1, 2, and 3. 1, 2, and 4.
1, 2, and 4.
Mr. B. Diori, accept notice on behalf of respondent number 3.
3.
Extra copies within 3 days. Tendency of the writ petition shall not be a bar for the respondents to act upon the recommendation of the independent authorities for provincializing the services of the petitioners.
Lord,
All right.
may I? Item 15,
List.
same, only
Ah.
district is different. Item 15, 1, 5.
Just a minute, list again on so and so, give a date. Sure. Item,
15, 1, 5. Only date is, only my lord, district is different.
give me the paper, file. Only what is different?
Let's district, my lord. It is from another district.
Did I mention district?
District Hubli.
I did not mention district. Similar order.
My-
How many petitioner here?
2 petitioners,
Okay.
the same reason,
Similar order.
opens.
May please, your office. Here, my lord, I am aggrieved by continuation of my suspension period, my lord.
Hmm.
I was suspended on long break, my lord, on 11/1/2024, my lord, Annexure 4, page number 31, my lord. I have been working as an assistant teacher at Gonakpukhuri High School, my lord. And during my service, my lord, I was arrested in connection with a case and immediately I was suspended, deemed to be suspended, my lord. 31 is the page by which I was put under suspension, my lord.
Hmm.
So my case is here is that after my suspension, my lord, it was not reviewed, my lord. And almost 2 years has been expired. So at this stage, may I pray for an call for an instruction, my lord?
You are under suspension till today.
Yes, my lord. So at this stage, my instruction may be called for instead of issuing notice, my lord, because this is the limited issue, my lord.
Who is appearing? You have instructions?
No, my lord.
Okay.
Just come up for the first person.
First time, Mr. Tawag.
Third, Mr.
MAI Hussain.
M.A.I. Hussain, Learned Counsel for the petitioner who submits that the petitioners agree with the with this prolonged suspension. Ever since the order of suspension was passed on 11/1/2024, with effect from 23/12/2023. Stop, he submits that the suspension period has not been reviewed till date. And therefore, the same is in violation of the established principles of law laid down by the Apex Court. In view of above, issue notice of motion returnable by short date,
Short date.
2 weeks. Mr. B. Kaushik, Learned Standing Council, Secondary Education. All the respondents. Extra copies be served to him within 3 days. Mr. B. Kaushik shall obtain instructions by the next day. List again on so and so.
11th.
Wait, please, Your Lordship.
Yes.
Lordships, in this case, the petitioners before your lordships are contractual teachers as on today.
Hmm.
But however, they've been getting the regular pay scale.
Hmm.
Now, we are essentially aggrieved by page 181, which is annexure P22, if I may just place it, lordships. This is an advertisement dated 1/12/2024, which seeks to regularize persons like us. May I just place this, lordship?
Yes.
And this, I may just point out at the very outset, this advertisement is a subject matter of challenge pending before this court in other matter where notice has been issued. That order also, lordships, will hand over to order.
Yes.
With a view to support, strengthen, and improve the quality of secondary education in the state of Assam, and in pursuance of government approval by letter dated 21/11/2024, and in exercise of powers under the Assam Secondary Education Provincialization Fourth Amendment Rules 2024, online applications are hereby invited from willing and eligible candidates who are working as additional contractual teachers, which under secondary education through the official website of DSC Assam so and so, in the initial pay band 2 PB2 of 14,000 to 70,000 plus, grade pay of 8,700 per month, and other allowances as admissible as per the Assam Services Revision of Pay Amendment Rules 2019. The conditions of recruitment is what we are aggrieved is 1, 2, 3, and 4. Rest may remain. The regularized teachers shall be provided basic salary with admissible allowances, and the first increment be given only after 1 year of regularization of services satisfactorily. May I just pause and say what is the problem here? The problem today is we are today getting, since 2020, regular scale was extended to us. And after 4 increments, that is 2020, 21, 22, 23, today we are drawing a salary of 26,700. And if this is to be accepted by us, then we go to 22,700. From 2020, regular scale was extended, and every year we got an increment. So today, as on today, we are drawing 26,700. If one is to be given effect to, then our salary will go back to 2,700 because they are not giving us any increments. We are not getting the benefit of increments. So we start afresh, and that will be evident from clause 2. The post will be prospective in nature no pay protection for past work can be claimed. So these advertisement came up for consideration before this court, and the court has issued notice and has also ordered that these it'll be final outcome of the writ petition, how these things will work. Now, lordships, and
So-
lordships will kindly appreciate.
So
number
you're
two-
challenging this,
Pardon,
you're
lordships.
challenging this in this writ petition.
Yes, lordships. This is that order passed. And it says the posts will be prospective in nature. In the teeth, if I may just place, if lordship is having a look at the order,
Mhm.
kindly come to page 18. That is where the order starts.
Mhm.
Heard so-and-so learned senior counsel assisted by so-and-so learned counsel for the petitioners and Mr. Saika learned AG and senior counsel assisted by Mr. Chishti learned standing. In this petition under Article 226 of the Constitution of India, 43 petitioners have prayed for the following reliefs. To set aside clause 1, 2, and 4 of the advertisement dated 2/12/24, the same advertisement.
Yeah, in your case, you said 3 also.
Yes, we are adding 3
1,
also.
2, 3, 4.
1, 2, 3.
Here it's 1, 2, and 4.
1, 2, and 4. To direct respondent authorities to count their past services to grant benefit of seniority and pension, and to declare and direct that the petitioners are qualified for pension under law and benefit of pay protection for the length of service already undertaken. And finally, lordships will kindly see the order that was passed at page 22, para 10 and 11.
Yes.
And we would like to add here to this is that if lordship will remember proposition B of that Constitution Pension Direct Recruits, here is a case where admittedly we were contractually initially appointed, not strictly as per rules, but we continued without break. Now our seniority will be from the date of our regularization, or will it relate back to the date if I may just put that proposition. So that will also come into play, because here is a case where from 2010 onwards, we have continuously worked. So therefore, you cannot say that it will be prospective. You may give us notional benefits. We may actually be given notional benefits, but for the purposes of seniority and other benefits, that purpose, if lordship will kindly come to para 47 of that direct para 47, lordship, that is at page 36. In fact, para 47, lordships. If I'm, after considering everything, that is page 744 of the judgment.
Mm.
To sum up, we hold that. Is lordships there? Lordship?
Yes, yes.
And I'm on proposition B, lordships. If the initial appointment is not made by following the procedure laid down by the rules, but the appointee continues in the post uninterruptedly till the regularization of his services in accordance with the rules, the period of officiating service will be counted. So today you cannot say it will be prospective and take away everything that is there.
So we'll issue notice.
We are just seeking issuance of notice at this stage, lordships.
Heard, Mr.
M. Goswami,
M.
Manish
Gos-
Goswami.
M. Goswami, learned senior counsel, assisted by Mr. R. Sinha, for the petitioners, who submits that by filing this writ petition, the petitioners have challenged the advertisement dated 1/12/2024, bracket annexure 22. Insofar as condition,
Advertisement is 212, lordships. The page
Page 182 is there.
212, no,
212.
212, lordships.
we see
Published on 212.
page 181,
181, 212.
see the signature date.
Well, the published date is 212, 182.
The published date is 212.
What did I say? You write this. Advertisement dated 1/12/2024. Annexure 22, the remaining you cut. Which was published in the local daily on 2/12/2024. Insofar as condition of recruitment numbers 1, 2, 3, and 4 are concerned. Stop. The Learned Senior Counsel submits that. Although the petitioners are working on contract basis, they have been enjoying regular scale of pay. And if the conditions impugned in this writ petition are to be implemented, they would be deprived of their earlier pay and taken to a level which is much below than what they're getting as on today. Stop. He submits that similarly situated persons have also approached this court by filing WPC number 4795 of 2024. And
Not 47 Rorships. That is 6, 4.
this is what you gave me.
No, but that is the, what is it a current, is a connected order, Lordships? Now, because the order in which it is passed is page 9, WPC 6525 of 2024, internal page. Linked case, Lordships.
Link case, but these are a
I'll
bunch
tell
of
you, Lordships, initially 2020 notification was challenged in that 4-5 thing. And the same set of petitioners then challenged the subsequent. So those two matters came up together. But the challenge to this advertisement is in 6525.
okay. What did I say? And cancel the number by filing writ petition. WPC number 6525 of 2024. And this court, white order dated 20/12/2024, while issuing notice of motion. Observe that implementation of the condition number 1, 2, and 4 of the same advertisement challenge in the said in the extended petition will be subject to the final outcome of this writ petition. Most of the Learned Senior Counsel submits that in the present case, the petitioners are also aggrieved with condition number 4 as well. Stop referring to the case of direct recruitment class 2 engineering officers association versus state of Maharashtra and others, 1992 SCC 715. He submits that if the initial appointment is made by is not made by following procedures laid down by the rules, but the appointment continues in the post uninterruptedly till regularization of service, the period of officiating service has to be counted towards seniority. Similar is the claim of the petitioners in the instant case as well. Next para in view of above, issue notice of motion returnable by 4 weeks. Mr. B. Kaushik, Learned Standing Counsel. Higher or secondary
Secondary.
education.
For respondent number 1, 2, 3, 4, 5, and 6.
Accept
One
notice
to
on
six.
behalf of respondent numbers 1, 2, 3, 4, 5, and 6.
7, my lord, my friend would be.
Ms. R. M. Barua, accept notice on behalf of respondent number 7. Notice is complete. Extra copies within 3 days. Will we club it together with that, please?
Not necessarily because I believe let it be independent because there I believe the seniority issue they have not raised.
Okay.
That's very important for us. So let it not be tagged for the timing.
List again after 4 weeks. It is further provided herein that implementation of the condition numbers 1, 2, 3, and 4 of the impugned advertisement shall be subject to the outcome of the repetition.
I'm very, very grateful, Lordship, very grateful.
These persons were appointed as assistant teacher in 1994. They got some salaries for a few months. Then thereafter, they were appointed as tutors in the year 2021. And similarly situated persons, they came before this honorable court. And this honorable court by an order, judgment dated, page, relevant is it page 188. On the basis of a division bench judgment, this court has disposed of the matter. Page 188.
Yes.
These petitioners are similarly situated.
We are aggrieved by which order?
Page 188, madam.
That I've seen already.
Yes.
You are aggrieved by which order?
No, I'm not agree, but I'm seeking similar order. Because I'm similarly situated persons, like that of the petitioners in this writ petition at page 188.
So what is your claim?
My claim is, my lord, we should be regularized.
Regularized.
Yes, and we should be, the page 190, your lordship will kindly see. Accordingly, taking note of the submissions, learned counsel, both parties, this court is inclined to dispose of the petition by directing the petitioners to file their individual representation to so and so along with a copy of this writ petition and relevant annexures and decisions so and so with a certified copy of this order, and such representation being filed by the petitioners. The respondent number shall examine the matter, and if the present petitioner is found to be similarly situated with the petitioners in so and so, then similar benefits may be granted to the present petitioners also. Now, similar benefit is, your lordship will kindly see page 189 on the basis of a division bench judgment of this court. Page 189. The relevant paragraph is quoted there, paragraph 179. It is true that the courts cannot direct the legislature to enact law in particular manner. However, in discharge of its statutory obligation, government in exercise of its rule-making power will have a duty to frame rules for proper implementation of the provisions of the statute. While framing the rules, the state will also be under a bounden duty to not only to act in terms of the scheme of the act, but also to unflinchingly adhere to the constitutional norms of equality. It will therefore be in the fitness of things that the state government itself, in exercise of its rule-making power under Section 23 of the Act, takes necessary steps to provide for a regular pay scale to the tutors, because these tutors are getting a lump sum pay of ₹10,000, which can even be commensurate to the pay structure indicated in the schedule of the Government Act. Such a measures, in our view, will restore the equality of treatment to this category of teachers with the other government employees, and at the same time will not become burdensome to the exchequer. We therefore direct the respondents to initiate necessary steps in the matter in the light of the observations made therein. So these petitioners also, my lord, they were appointed in 1994 and they were appointed as tutors. Your lordship can get it at page 85. Page 85, these three series. My lord, it will show that petition number 1 is appointed as teacher in the year 2021. So therefore, my lord, as your lordship got it, 85. And this whole series, 3 series, my lord, shows the appointment of all the petitioners. They were appointed as tutors. So therefore, I am praying for, because they are entitled to get regular salary. So they went to the division bench. Division has passed that order. On the basis of the division bench order, the largest single judge has disposed of the petition to provide the similar relief to the petitioner after considering that their representation.
Where is the division bench judgment?
Division bench judgment, my lord.
Have you annexed it?
No, that is quoted, my lord, at paragraphs 179. I have not annexed it, but
Orally shake.
2024 5 GLT 689. Page 189, my lord.
That is Mohar Ali Sheikh.
Yes, ma'am. Mohar Ali Singh.
After Mohar Ali Sheikh also, there was another case.
Mal-
Recent.
That I don't know. Well, maybe, well, that's all. It should be in the similar line only.
In terms of Mohar Ali Sheikh, only another division bench judgment was there. Recent one.
Which one? Which one? That is single bench. isn't it?
What do you say?
Single bench.
What do you say, Mr. Pegu?
So it's in similar line, it can be disposed of, my lord. They are similarly situated persons.
You're not sure?
My lord, yes, my lord.
Can it not be disposed of? Because ultimately it'll come to that only.
Yes,
Court cannot examine and say who is who and how much should they get.
yes.
It is the respondent authorities who will determine that.
Yes.
And if similar situated persons had come to this court and court had directed the respondent authorities to examine and give them a pay scale which according to them is the correct scale for them, it can be disposed of like that. Right. Art Mr. B.D. Daslana, Senior Counsel, assisted by Mr. S. Bora for the petitioners, who submits that the petitioners were initially appointed as assistant teacher, Hindi teacher in different ME school on regular scale of pay on the recommendation of the advisory board sometime in the year 1993 to 1994 in the district of Bongaigaon. So although they were paid salaries for initial 3 months, but thereafter the same was discontinued. And the petitioners came to be appointed as tutors under the provision of section 2 bracket small u of the Assam Education open bracket provincialization of services of teachers and reorganization of educational institutions close bracket Act, 2017 in different ME schools by an order dated 30/1/2021 at a fixed salary of rupees 10,800 per month with effect from 1/11/2020. So he submits that the petitioners are discharging similar duties and functions as that of the regular teachers, but they have been deprived of regular scale of pay. Full stop. He further submits that the case of the petitioners, in fact, is squarely covered by the decision rendered by division bench of this court in Mohar Ali Sheikh and others versus State of Assam and others, reported in 2024, 5 GLP 689. Wherein the court directed the respondent authorities to determine the regular pay scale to the tutors. Which is commensurate to other government employees. Within a time frame of 6 months. Full stop. He further submits that relying upon the case of Mohar Ali Sheikh and others, a number of similar situated persons had also approached this court by filing their respective writ petitions. How many writ petitions were there?
There, only one.
Only one.
Yes. But
By filing, not many writ petitions. by filing WPC number 5436 of 2025. And a coordinate bench of this court, white order dated 17/9/2025, disposed of the writ petition by directing the petitioners therein to approach the respondent authorities concerned to file their representations individually and with a further direction to the respondent authorities to dispose of such representation to be filed within a time frame.
Instead of individual, if your lordship allow jointly, that because otherwise individual, everybody will have to provide a copy of the writ petition. Jointly, they will submit, madam. It will become easier for the authorities, easier for the petitioner. I leave it to your lordship.
Individually will be okay, because
Please, sir.
most of action is separate, all are separate.
So I leave it to your lordship. It will be cumbersome for both sides, madam.
Understand? And consequently, if the petitioners are found to be eligible, found to be similarly situated, similar benefit be granted to them as well. To stop, he thus submits that the instant writ petition may be disposed of in similar lines as well. Stop. Although Mr. G. Pegu, learned standing counsel, elementary education, and Ms. R.M. Borua, learned standing counsel, finance department, seek for some time to receive instructions in this regard. But having regard to the projection made by the petitioners, and importantly, in view of the earlier decision rendered by this court in Mohar Ali Sheikh Supra, and also in WPC number 5436 of 2025, the writ petition is disposed of. One of you can annex the writ petition. Everyone need not.
Yes,
Who will annex?
Yes, ma'am.
petition number 1.
With a direction to the respondent, with a direction to the petitioners to submit their individual representations along with a certified copy of this order. Full stop. It is further provided herein that all the writ petitioners need not submit a copy of this writ petition. And only the petition number 1 may submit the copy of the writ petition with annexures, and the respondent authorities shall consider the same. To be sufficient. Stop. Upon receiving the representations to be filed by the petitioners, the same be considered. Any authority to be before whom it should be filed.
We will file it before the commissioner secretary, madam.
Respondent number
2.
Can you just read that part? Dispose of by directing the petitioners to. Not full stop. After that, before the respondent number 1. Then stop. Then. And the respondent authority. Yes, you can, authority, one only, no? Shall consider the same to be sufficient. And in the event it is found that the petitioners are similarly situated, as the petitioners in Mohar Ali Sheikh, Supra, as well as in WPC number. So and so, what was that number again? And WPC number 2729 of 2019, similar benefit be granted to them. Stop the entire exercise be carried out as expeditious as possible and at any rate within the outer limit of 3 months from the date of receipt of a certified copy of this order.
This has lessened the burden of the petitioners, also the respondent.
Right.
Right.
May I please, your lordship, matter may be passing on to the time being lordship.
Notice to go ahead,
The petitioner is an assistant professor in Pandit Deendayal Upadhyay Mahavidyalaya. So what has happened is, from his salary, the NPS amount was deducted since September 2017. And when he checked up in his NPS account, he can check it up personally, my lord. When he checked it up, since September 2017 to July 2020, that NPS amount has not. My lord. My lord, I'm sorry, madam. Just let me verify once.
Correct. Page 11,
My,
September 18,
yes,
not 17, right?
yes, yes.
Or is it 17 and this is wrong?
My lord, actually it is 17.
17.
My lord.
Your synopsis says 17.
Yes, yes, and my.
Prayer says 18.
And my body also says 17, my lord.
You want to rectify it?
My lord, I'll rectify it.
Better rectify.
Yes.
Mr. R.P. Bhardwaj, learned counsel for the petitioner, submits that there's some clerical error in the prayer portion of the petition, and he may be allowed to file an additional affidavit, or file an application for correction of the same. Praise allowed. When will you file?
Or I can file an affidavit, man.
No. You file an application. We'll allow it and then you correct it. You replace it. List again on so and so.
I'm the respondent of 7 minutes. Yes.
God bless.
Yes.
May it please, Lordship. Lordship, this petition has been filed for limited purpose, Lordship, and the page number 12, Lordship. A warning order was issued to me that has been challenged, and court has observed that, Lordship. Court has observed that
What?
you proceed to the, if, may I read, Lordship, page number 12, last paragraph.
You had come before the court earlier.
Earlier.
This is second round.
Yes, second. In, may I read, Lordship, page number 12. In view of the petition is hereby disposed of by the inquiry authority has, court has asked to proceed to discipline proceeding to the commissioner. And Lordship, that order has been complied, Lordship, and page number 16, Lordship. Page
No,
number,
don't hush up things like that.
Lordship.
We have to understand to pass the order, you
Lordship.
see, the council. You had come before this court earlier,
Earlier.
and I think you are aggrieved by some sudden communication. Then
This has been disposed, Lordship.
read the last para in page 12.
Page 12, Lordship. In view of the above petition, this petition is hereby disposed of by requiring the secretary to the government of Assam, Secondary Education Department to consider the allegation available against the petitioner on record, and if misconduct is borne out thereon against the petitioner, to initiate the departmental proceeding against the lead petitioner, strictly in accordance with the procedure of Rule 9 of the Assam Service Disciplinary Rules with a period of 1 month from today. That has been done, Lordship.
So what was the reason why you filed the first writ petition?
Lord, first was, Lordship, warning letter was issued to me without hearing me. So I have filed this
Warning letter dated
warning letter dated, Lordship, 6/4/2019.
Okay, 6/4/2019.
19. That's what set aside.
It has been written as communication.
Communication. that's
Okay.
right.
Then thereafter,
Then-
what happened?
Then page number 16, Lordship. And the last paragraph, order, Lordship.
Page?
Page number 16. 16.
What is this?
This is order passed by the Commissioner and Secretary. Lordship.
The court has directed some order be passed.
Yes, after careful consideration of the above stated facts, materials on record, and findings on the inquiry regarding several allegations of misbehavior and mental harassment of lady teachers of the school submitted by Director of Secretary of Education, Assam, the Director of Secretary of Education hereby directed to immediately suspend Sri Midul Kumar Laskar, Headmaster of Dakhin Kambur Surenso, under rule of the Assam Service Discipline and Appeal Rules, and take necessary action to do disciplinary proceeding against him by appointing an inquiry officer with the direction to conclude the inquiry within a month and furnish a detailed action taken report on the matter aforementioned DP in the Department of School Education. Then I have been suspended, Lordship. I again come before this court after suspension, Lordship. Then my suspension was reviewed. The suspension was, then page number 19. Page number 19. I have been reinstated by the page number 19, Lordship, by the Director of Director of Education, and posted in another school, which is far 70 kilometers away. Now I am not on this. I am in this that you conclude my department proceedings, and therefore I have submitted representation before the Director of Education, before the Appellate Authority. But till date, from 2014, no department inquiry has been concluded. So my limited power is to only conclude departmental proceeding within a time limit.
Where's your show cause? Please tell me. Thirteen 2025. Page 21, Annexure 7. Paragraph number 5. Mr. U Sharma, you obtain instructions? You are covered by which department? Secondary or higher? Secondary. Then Why are you raising that issue, Mr. Sharma? Huh? I'm asking you to get instructions, that's all. Why are you raising all those things now? You represent which department? Then get the instructions. By filing this writ petition, the petitioner is aggrieved with the action of the respondent authorities concerned in not concluding the departmental proceedings drawn against him pursuant to the show cause notice issued to him on 13/3/2025. Heard Mr. D. Mahanta, learned counsel for the petitioner. Issue notice of motion returnable by 2 weeks. Mr. U. Sharma, learned standing counsel, secondary education, accept notice on behalf of respondent numbers 1 and 2. Extra copies be furnished to Mr. U. Sharma within 2 days. Mr. Sharma shall obtain necessary instructions with regard to the status of the department proceedings by the next date. Give a date. List again on 10/12. Page number. Page number 111. This is an order dismissing you from service. What happened to the appeal? Your appeal is page 114. When did you file it? 18/9. So we'll issue notice. We'll issue notice. When is it about to retire? When will he retire? Before you retire, you have been dismissed. So you cannot say that I'm going to retire in July 2026. You are no longer in service. And if your dismissal is interfered with, definitely the consequential benefit should be given to you. So at this stage, we'll issue notice. What can be done? Heard Mr. M.K. Bora, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the impugned order dated 22/7/2025, by which the petitioner has been dismissed from service and disqualifying him from future employment in terms of Rule 7 bracket small Roman 7 of the Assam Service open bracket discipline and appeal close bracket rules, 1964. Stop. The learned counsel submits that against the order of dismissal, the petitioner preferred an appeal Is this the channel to prefer appeal before the governor? Mr. Kaushik? Appeal has to be preferred before the governor? Appeal before the governor of Assam on 18/9/2025. By invoking the provisions of Rule 13 of the Discipline and Appeal Rules 1964. But the same has not been considered and disposed of till date. Stop aggrieve the petitioners before this court. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr. B. Kaushik, Learned Standing Counsel. Secondary Higher Education Department, accept notice on behalf of respondent members. 2N. Elementary. Respondent numbers. What about 1 and 2? 1, 2, and 4. No. The reason perhaps is because the inquiry officer was from higher. Are you sure? If you want to correct, you may correct number 3. I'll not say anything. List again after 3 weeks on registry to reflect SC elementary instead of SC higher education in the cost list. elementary education. So he further submits that pending disposal of the writ petition. The respondent may be directed to release the current salary of the petitioner with effect from 1/11/2025. Next, the review for public notice the motion to govern by TV. If it's, if we are not, coming up with limited dictation of such notice on behalf of respondent 1 to 4. Yes, I am Barua, that's Sunny Dr. Finance Department. So please on behalf of respondent. Notice is complete. Extra copies with it. Edicts. List again on some, so give a date, December. On 12/12/2025, by which time the Learned Assembly Council, Elementary Education shall obtain its completion on the interim frame made by the petitioner. Yes, go on.
Order of the others. The respondent number for both honorable court by filing a writ petition. Hereafter, getting order was passed. It is a phase 22. That's that period. Lordship, kindly peruse page 24, Lordship. 24, Lordship. Considering the prima facie case being made out and in view of the balance of convenience and irreparable loss that the petitioner may suffer, the further effect of provincialization be not given to respondent number 6, that is the petitioner, Lordship, until further orders, Lordship. Thereafter, kindly peruse page 25, Lordship. Annexure F, Lordship. In compliance with so and so, the monthly salary of the petitioner is hereby temporarily stopped, Lordship. Then what has happened, Lordship? After hearing the parties, Lordship, the said writ petition was disposed of, Lordship, with certain directions, Lordship. Kindly peruse page number 30, Lordship. Relevant part, Lordship. Page 30, Lordship. Can I go through it, Lordship?
Yes.
third last paragraph, Lordship. Considering the above and from the DISC data of the year 2011-12 of said Rajadwar Simantawati ME School annexed by the petitioner, it is found that the petitioner is senior to the respondent number 6. As such, the petitioner is directed to approach the concerned educational tribunal of Lakhimpur district for provincialization of his service. Which the respondent number 6 on or before 30/03/2023 along with the certified copy of this order and a copy of the writ petition, including the annexures appended thereto with the prayer for interim order, Lordship. In the event of filing any such appeal by the petitioner before the concerned education tribunal within the time so specified as directed above, along with any prayer for stay of the order number so and so passed by the Director of Elementary Education Assam, provincializing the service of the respondent number 6, that is the petitioner, as a tutor in so and so school, the authorities concerned of the said tribunal shall consider the same in accordance with law, determining who amongst the petitioner, the respondent number 6, is entitled for provincialization of their services under the provisions of the said 2017 Act, amended in 2018, after giving an opportunity of hearing both the petitioner as well as the respondent number 6 and after verifying the relevant records. However, it is made clear that till such approach of the petitioner before the educational tribunal up to 30/03/2023, Lordship, the impugned provincialization order of the respondent number 6, Lordship, that is the petitioner, issued by the Director of Elementary Education Assam noted above shall remain suspended. Thereafter, it is important, Lordship, thereafter the concerned educational tribunal shall consider regarding interim stay or provincialization of the service of the respondent number 6 if any such prayer is made by the petitioner in and or along with his said appeal, Lordship. So after the direction of this honorable court, Lordship, the respondent number 4 approached the concerned educational tribunal. Thereafter, he had filed one miss case, Lordship, for temporary injunction, Lordship. Kindly peruse page 32, Annexure 8, Lordship.
Then what happened? Granted?
His interim prayer was rejected, Lordship.
Okay.
His interim prayer was rejected, page 32, Annexure 8, Lordship.
Then?
Lordship, his interim prayer was rejected, Lordship. Thereafter, the petitioner approached the concerned authorities for release of his payment. Since his interim order was rejected, Lordship, but till that salary has not been paid, Lordship. Till now, Lordship, 3.5 years, he has not been paid the salary, Lordship, 45 months, Lordship. Because on the basis of this honorable court order, Lordship, he approached the concerned education tribunal, Lordship. His prayer was rejected. His interim prayer was rejected, Lordship. Rejection order is at page 32, Lordship. So provincialization has not been stayed, Lordship.
Petition has been provincialized, isn't it?
Lordship, petitioner service has been provincialized. That challenge was made before this honorable court. Honorable court asked the respondent number 4 to approach the concerned education tribunal, Lordship. Thereafter, he had filed an miss case for stay of the provincialization of the petitioner, Lordship, which has been dismissed, Lordship. But in spite of repeated representation before the concerned respondent authorities, Lordship, his salary and pending dues has not been released till that, Lordship. That's my case.
You are saying respondent number 4, it should be respondent number 5.
Lordship. Lordship, respondent number 5, Lordship. Sorry.
Third, Mr.
P. Bordeloi, Lordship.
P. Bordeloi, Learned Counsel for the petitioner, who submits that being aggrieved with the provincialization of the services of the petitioner, respondent number 5, file WPC number 4246 of 2021, which was disposed of on 10/3/2023 by directing the respondent number 5 to approach the tribunal concerned along with interim prayer
for stay
of the provincialization of the instant writ petitioner. Stop. Although the respondent number 5 approached the tribunal in terms of the court's order and sought for stay of the provincialization of the petitioner's service, the tribunal declined to stay. the petitioner's provincialization. But despite the same, the petitioner has not been given his salary since 22/3/2022. Accordingly, the petitioner prays for direction to the respondent authorities to release the salary
And the pending dues, lordship.
along with the pending dues. In view of above, issue notice of motion returnable by 3 weeks. Miss
And Fukan?
N. Fukan, learned Standing Council Limited Education accepts notice on behalf of
1 to 4 months.
small numbers 1 to 4. Anyone else?
Lordship, in the interim,
Okay.
lordship. Lordship, that
Petitioner-
Ryan salary may be released, lordship.
Petitioner,
Because order it is clear, lordship.
just a minute, I have not completed.
Lordship. Sorry, lordship.
Petitioner to take steps for service of notice upon respondent number 5 by registered post with AD within 3 days. Extra copies of the writ petition will be furnished to Ms. M. Fukan within 3 days.
Order in the
Also issue notice on the interim prayer. Returnable by, give a short date. 11/12/2025. On which date the Learned Council for the Elementary Education shall obtain instructions as to why salary of the petitioner has not been released till date. Full stop. List accordingly. We'll see on that date.
My love, 11/12, lordship. Oblige, your lordship.
Meet please, your lordship. Lordship, matter pertaining to non-release of salary, lordship. Petitioner service in post of LDA, lordship.
TA,
LDA, lordship.
where?
Lordship, earlier, one namely Saleha Begum Laskar filed a writ petition before this court to challenge provincialize of service of the petitioner, lordship. And writ petition is allowed, lordship. After that, petitioner filed a writ appeal and writ appeal is dismissed, lordship.
So you have no case.
Lordship, one communication dated 15/2/2024, Annexure D, lordship, page 660, lordship.
No, earlier who filed writ petition?
One namely Saleha Begum Laskar, lordship. She is also LDA.
Claiming what?
Lordship, she Annexure D,
Page?
page 60, lordship.
Page 6.
60, lordship, 60. Communication issued by Director of Secondary Education Department to Inspector of School, lordship.
No. You show me the writ petition order.
Annexure A, lordship.
You said somebody filed writ petition.
Yes, lord.
Who is that?
Saleha Begum Laskar, lordship. In this writ
Where is
petition-
that? Where is the order?
Lordship, start from 14, page 14. Relevant para is lordship 39, page 27, lordship.
You were also a party there.
Yes, lordship. I am respondent number 8, lordship.
Why are you respondent? What was the grievance?
Lordship, challenge my provisionalized of service, lordship.
Okay. Then,
Lordship, writ petition is allowed, lordship. After that, we file writ appeal, lordship.
then writ appeal was dismissed.
Dismiss, lordship.
So you have no case then.
Lordship, I continue service, lordship, but from February to August, lordship, 2024.
You are asking for
My
salary.
attendance, yes, lordship.
You are asking for salary for which period? For the
February to
period-
August, lordship.
For the period which you worked.
Yes, lordship.
You were serving within this due dates.
Lordship, page 59. Attendance register, Lordship.
Hard Miss, what's your name?
F. Begum.
S. F. Begum, learned counsel for the petitioner, who submits that the services of the petitioner was provincialized as LD assistant,
LD, Lordship. Junior assistant, Lordship.
LD and junior, they're same.
LD in the school, Lordship. Lower division assistant, Lordship.
And the other one, junior,
Same, Lordship.
same. I thought they were different. Provincialized as LD assistant, which was challenged by one Saleha Begum Lashkar by filing WPC number 2428 of 2016. But the writ petition came to be disposed of in favor of the writ petitioner by judgment and order dated 16/6/2023. Stop aggrieved. The petitioner filed writ appeal number 100 of 2024. But however, the appeal of the present writ petitioner was dismissed. Stop. The learned counsel submits that claim made by the instant writ petitioner is with regard to the salary for the period for which she had rendered her service. She or he? She had rendered her service. That is February 2024.
I'm
Standing
appearing
counsel.
for 1, 3, and 4.
Patient is on or as 1, 3, and 4. Ms. R. M. Barwal, and Standing Counsel at Finance Department, accepts notice on behalf of respondent number 2. Notice is complete. Extra copies be furnished to the learned counsels for the respondents within 3 days. List again on so and so. 12. Learned Standing Counsel for the Finance Department as well as the Secondary Education Department shall obtain instruction with the regard to the non-payment of salary to the petitioner for the period which she had rendered service by the next returnable date.
Lordship, pendency not a bar for release the salary, Lordship.
Further, pendency shall not be a bar to release the salary of the petitioner as claimed for.
Deeply opposed.
May it please your lordship. My lord, the petition. The petitioner is the deputy registrar of the respondent university.
Your case is item 1 of the production list.
Item 1 of production list and also the item 56 in the supplementary list.
Okay,
So 56 was filed first, my lord. I am submitting the 56 first.
okay. Yes.
Here, my lord, the petitioner is the deputy registrar of the respondent university. Now, from 2nd of July 2025, he has been allowed to hold the charge of registrar. Thereafter, my lord, an advertisement has been issued inviting applications for the post of registrar to be filled on regular basis. In that application, I have also participated. I have responded to the advertisement and I submitted my candidature.
Your substantive appointment is deputy registrar
Deputy registrar.
and that register post is vacant.
Yes, yes,
Advertisement, you
Yes.
applied.
yes.
Okay, then
Substantive appointment is deputy registrar, but I am holding the charge of registrar.
charge, okay.
Holding the charge of registrar. That is an ad hoc arrangement made. Now there is an advertisement which requires the post to be filled up on regular basis. The ad hoc arrangement was made on the condition that I will continue to hold the post till the regular incumbent is appointed. Now, on the face of the advertisement, my lord, I also respond. The last date of submission of the responses was fixed on 30th of August 2025. Now, on 13th of this month, my lord, a list is published in the website, which I have enclosed in the writ petition, which shows that there are altogether 12 aspirants. Whereas on the last date of application, my lord, there were only 5.
Last date was?
Last date was 30th of August 2025.
Okay.
And on the last date of the application, my lord, there were 5 contenders, including me.
Yes.
Now, 13th of November, my lord, a list is published on the website. And from there, I come to learn that there are altogether 12 candidates. And the extra 7 candidates are apparently, my lord, persons who had not submitted their application within the time stipulated. Additionally, my lord, what they do, in the 13th November publication, they put down certain criteria to be fulfilled by each one of the candidates. I am one of the candidates, so they insist on submission of certain documentary papers. My contention in the writ petition is that this exercise undertaken by the screening committee, so to say, are barred because of 2 reasons. Number one, they cannot expand the pool of the candidates going beyond the date notified. The date notified was 30th August, and therefore the eligibility has to be judged on the basis of that date. They cannot expand the pool of candidates by including names who apparently did not file the applications within the time stipulated. This is the first contention. The second contention is that, my lord, the kind of documents that they are now practically irrelevant to the issue. If your lordship will kindly see, to formulate that point, my lord, I would just take your lordship to the advertisement. The advertisement and the terms of advertisement, your lordship will find at page 31. Yes. 31, right?
Yes.
So page 31, clause 15, your lordship will kindly see. The filled in application form should be addressed to the registrar, so and so, in an envelope superscribing so and so. And has your lordship got it, my lord?
Yes.
Now, this is the clause 15. And I have made a statement in para 9 of the writ petition, para 12 at page 9, indicating, my lord, the responses that were received by the deadline.
No, where's the dead? What is the last date?
Now, this last date was initially, my lord, it was in the month of July. This was later extended, my lord. The subsequent page 33, your lordship will kindly see. Sorry. Annexure 5, your lordship will 34, your lordship will kindly see. This was extended up to 30th August.
So this is the last extension.
Last extension.
Beyond this, no further extension.
Thereafter, no further extension.
Okay.
Now, who were the candidates who had filed in the application, my lord? That disclosure is at page 9, paragraph 12. And the document, my lord, I did not get the document at the time of filing, my lord. It has come to us subsequently.
Now, what's so special about this para 15?
Para 15 is that, my lord, the application has to be sent to the registrar.
So?
And it has to be sent within 30th of August. Now, 30th of August is the date fixed as the last date of application, based on which, my lord, the eligibility will be judged. Now, altogether, 5 applicants were there till 30th of August.
And this information, from where did you get?
Information regarding the filing of application, my lord. 5. My lord, I have made a statement in para 12, my lord. The document I received late, your lordship may kindly peruse this.
What is that document?
Well, it's a document prepared in the office of the respondents. Your lordship will kindly see the number of applicants.
No, you said you received late after filing of writ petition.
Yes. But the averments I made already in the petition.
No, that's what I'm asking you. How did you know that there were only 5 candidates?
Well, it will be from the list.
This
now that I have just now submitted, yes.
This you came to know later on.
No, this was not in my position, my lord, but I had a knowledge of this.
How?
I am the registrar. I was holding the charge of the registrar.
Well, he is the in charge.
I am the person holding the charge of the registrar. My lord, the applicants
He is
were,
in office. my lord.
applications were received in the office of the registrar only.
He is himself, everything.
Okay,
Now,
application was addressed to you.
yes,
That's
no,
in
not
charge
to
registrar.
me, my lord, to the office of the registrar.
Correct. To
So-
you means you are
yes.
holding the charge.
So this
So you
was,
know,
yes,
so you know how many applications are there?
yes.
That
So-
much I wanted to know. That's
Yes,
all.
so there were 5. Now, if your lordship will kindly see the page 35. Page 35 is a list published by the university, my lord, where they extend the pool to total 12 number of candidates.
No, just before that, this document you're giving me. Who is the recipient?
My lord, next page your lordship may kindly see. It is an extract from the, it is a copy from the registrar. My lord, the respondent number 4 and 5, 5 and 6. 4 and 5. 4 and 5 are the persons, my lord, who had received the applications. Yes, my lord, they have been made party to the proceeding. I'm sorry, my lord, it is 6 and 7. No, 6 and 7. 4 and 5, my lord. 4 and 5 are the persons, they had received it. They are the officials, they had received it. Now, if your lordship will kindly come to page 35. No, next page your lordship may kindly see, which is a copy of the entry in the registrar. And also see the endorsement made on the body of it. Well, kindly see the name of the applicants. There are 5 applicants there. The dates of receipt of the application is also indicated in a column. And thereafter, your lordship will find the signature of the person who had received it. Now, these 2 gentlemen, one is Rakhal something and another is Sanjay De. And they have been made, my lord, the respondents in 4 and 5. Now, they are the private respondents, my lord, whose applications were not there on 30th of August. Well, that has been prepared by some staff of the office of the respondent university, my lord. No, it's not a party, but yes, it is a compilation of the my lord, it's a compiling statement of this register, this page, next page. Yes, my lord, the endorsement your lordship will see on the next page that total 5 numbers of applications received by registrar office handed over to VC office staff as on last date of application submission. Now, this particular person may be somebody in the office of the VC. Yes. Yes. No, that is the receiver. The receiver in the office of the registrar, the VC. Receiver of these applications, because the applications were sent to the VC's office. Your lordship will kindly see the endorsement made, my lord. Total 5 numbers of applications received by registrar office handed over to VC office staff. So the first page your lordship actually is looking at, that is the endorsement of the VC office staff. That he or she, I do not know, maybe she received it from the office of the registrar. Yes. There were. Yes. 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 And there were only 5. Now, if your lordship will kindly come to page 35. Page 35 is a provisional screening list of applications. Now, here, and your lordship will kindly mark the wording, provisional screening list of applications received for the post of registrar. And the total number of candidates here gets amplified to 12. Therefore, my case is that, my lord, the 7 extra persons who have been enlisted here, they are clearly beyond the date stipulated in the advertisement. They cannot take part in the selection process. Lordship.
My lord, what-
The last date was, the date of submission of documents was fixed on 20th of November. And thereafter, it has not been finalized as yet.
20th of November.
20th of November was the date. If your lordship will find that date at page 38. Page 38, last endorsement. All other documents mentioned in the remark column of respective candidates are also to be provided within 7 days. Publication of this list in the website of the university by 20th of November. That was the date fixed for submission of the documents. And till date, my lord, it has not been finalized.
So your first point is that there were only 5 persons. How come now there are 12 persons?
Yes,
So this extra 7 persons are not eligible to participate.
yes. And out of extra 7, my lord, 4 persons they have already declared ineligible in this list.
How,
In,
where?
in this list, page 36, your lordship will kindly see a person at serial 6. 9, 6 and 9 and serial 2. Serial 2, 6 and 9, they have been already declared ineligible. So it remains that the private respondents are the remaining persons. Private respondents from 6 to 9. The 4 persons, they are the late applicants.
persons.
Yes, late applicants, so to say. So it cannot be a case, my lord, where these persons can participate in the selection process. They having,
That is the only point?
yes.
Then why the second writ petition?
Now, second writ petition is this, my lord, because this case was filed on Monday, day before yesterday.
Hmm.
The moment we did that, they have now issued an order relieving me from duty from the post of the deputy registrar.
It's not-
Now,
it's the-
sorry, the registrar. Now, the appointment was made by the executive council, mandating that I will continue to hold office of the registrar as an ad hoc arrangement till the time a regular selection takes place and till the time the regular incumbent comes.
Where is that?
My lord, I'll take your lordship to the second writ.
Is it not available in this first writ?
Yes,
petition?
yes, it is. Yes, it is very much here, my lord. Your lordship can kindly see the page 33. Page 33, your lordship will kindly see. In pursuance of the resolution,
Okay, I got it. Till the new registrar joins.
yes,
That is the clinching thing.
yes, till the time new registrar joins.
Hmm.
Now, because I have filed this case now, they have relieved me from the post of deputy, post of registrar,
Hmm.
and by an ad hoc arrangement, they have posted there another
So
person.
they have rewarded you with relief order.
Relief order. But practically, my lord, although a paper transaction has taken place, that I was yesterday evening, I was made to sign a paper indicating that I have handed over charge. But practically, it is not complete because apart from the academic charges, I also hold the charge of deputy drawing and disbursement officer. And to cause a change in the holding of the charge, my lord, the financial the information with regard to the banking transactions are to be given. It has to be effected in the bank because I hold the power of the drawing and disbursement officer. That has not yet taken place. And my instruction is this, my lord. As per the statute, my lord, the appointment is by the executive council. My appointment, even on the ad hoc basis, my lord, it was by executive council. Yesterday, the VC has issued the order saying that the ratification of the executive council will be taken later. And I hope, my lord, perhaps by this morning, they have also taken the ratification. That is the case in a nutshell in the second case, because my contention there is that your lordship knows, my lord, then one ad hoc cannot be replaced by another ad hoc. Merely because, my lord, I have filed a case here, and that is the grounds taken in the impugned order. If your lordship will kindly see the order at page 15, they say that since I have filed a case against the university, page 15 in the second writ petition. They are otherwise very prompt, my lord. Immediately on the filing of the case, since there is a standing counsel, so they got the information and this is the order passed.
It is my duty to inform the company.
No, I am not imputing anything on you. I am saying about them. This is the haste with which, my lord, the order is passed. Kindly see page 15, since the case is filed and therefore he has to be relieved. My submission is that, my lord, even if that decision is to be taken, it is to be taken by the EC. You cannot put the cart before the horse. You place the matter before the executive council takes a decision, and thereafter you pass an order. It can be another manner. It is another manner if an order comes in that regard. Yes, yesterday evening, my lord, page 16 is the.
Is he also one of the contender?
No. He is only a probationer. He has joined the university just 2 months back.
Deep Ratna.
Yes, he is a he's
not a contender. for
No,
the
no.
post. Okay.
No. He has joined the university only 2 months back and he is going under probation. He is not even a confirmed employee. But somehow to dislodge me from the position, my lord, this order has been passed.
Yes.
Yes, my lord, there's
Mr.
some
Mehdi.
instruction I received, this is a design. My lord, the main thing is, my lord, so far this yesterday's order, my lord, just I am itself indicated in order 25/11/2025. This, my lord, lordship already read. I have read again, as per section 4.2.4.8 of the Rabindranath Tagore University Statute, registrar is required to represent the university in all court of law, in suit, etc. However, since present registrar so-and-so himself is a petitioner in the before Honorable High Court against Rabindranath Tagore University.
What are you reading?
My lord is, my lord, annexer
Which one?
2 to new read petition, my lord, and annexer 2 to the new read petition, my lord, annexer 2.
Yes.
As per section 4.2.4.8 of Rabindranath Tagore University, registrar is required to represent the university in court of law, in suit, etc. However, since
Understood, Mr. Mehdi.
yes, madam.
Conflict of interest.
Yes, madam. And madam,
Conflict of
yes,
interest.
madam. And the other, madam, whatever my instruction I received, madam, Lordship may peruse, madam. He himself inserts register, madam. And my lord, there is some the inquiry was conducted, my lord. There is some application was refused, my lord. During that time when they want to submit some application regarding this post, my lord, there was an inquiry also there, my lord. It was there, my lord.
Inquiry for what?
My lord, some selected application was received. Those who are this below the read petition, my lord. This was, my lord. So they refused to accept some application, my lord. Thereafter, there's one inquiry. One courier serviceman came to submit hand over this the one packet of application, my lord. And it was refused, my lord. Thereafter, one inquiry is conducted. It was reflected in inquiry. His packet was refused by the office of the registrar. Thereafter, what happened, my lord? Thereafter, another application is received by the office of the PC, my lord. And so far, this documents is concerned, it is not enclosed in the read petition. So in that case, I have to take instruction also, my lord. And so far, the main intention is, my lord, they to stop all this thing, all this advertisement and the selection process. He is deputy registrar. So when there was no competent person, he was given the charge of the registrar himself. And in that particular time, he himself in the office, and he himself applied for the said post.
Everything is used in this office so far. It was something, when extension, the earlier, initially when advertisement was made, it was, when he was not qualified.
Is it not permissible that person holding the charge of the post cannot be he himself
But
an applicant?
But question is there, this, so far this, when the university will contest the case, the registrar is the appropriate authority to contest the case. So this statute and regulation speaks.
No, I'm not on that. I've perfectly understood what you're saying. What I'm on is different. Supposing the present petitioner is holding in charge registrar. Post is vacant
You know, no,
and applicants are invited.
he can.
Can he not apply for the post?
He can, but.
Or
he-
will you say that you are in charge of registrar, you
No,
cannot
no,
apply?
No, that is not.
Then-
Here, where question is, only this screening committee was there as per the university rules and regulation. The rules and regulations speaks this, there is every right of the screening committee to go through all the papers, to the authenticity of papers. So thereafter, it was asked to all the candidates to submit the all relevant documents. Then when he thought that some documents there is deficiency, this petition is filed, and except all other submitted the relevant documents. Now it is my instruction. So only to stop this selection and continuing as the insert register, this petition is filed. So and he holding this insert post, and from his office, this prevented to submit some application for a said post. There's inquiry also. Your lordship may go through. Everything is come from the office of the university. So the man who is sitting in the said chair inserts register, and he applied, he from his office, then there's some application is prevented to receive. Then there's no other option, and now we have to contest the court of law. PC is not the appropriate authority as per the statute. So we have to relieve him. He is not permanent post. So he is deputy.
Okay. That is regarding relieving and all that. But insofar as the number of applications.
Yes, madam, it is also there.
Listen,
It is also.
please listen to me. Insofar as the applications received as on 30/8/2025 was only 5. But now it so happens that there are 12 candidates in the fray. That means
My lordship,
5 plus 7.
my lordship,
7 more have come,
my lordship,
and out of which, under document verification, 3 of them have been rejected. So, but still 5 of them are still there, who had submitted their application after the last date.
No, my lord, that is wrong. That is wrong submission. My lord, this annexer, 5 page 12 of my instruction, lordship may produce.
Then you do one thing. At this stage, we cannot determine what is what. You get your instructions and file it in the form of an
Yes, ma'am.
affidavit,
Yes, ma'am.
and we'll deal it finally
Yes, ma'am.
when you file it.
Yes, ma'am. It will take, my lord, 1 week time again.
1 week time. Till then, status quo.
No, my lord. No, my lord, that will be harmful to the university, my lord.
Why?
Because, my lord, this, my lord, everything, my lord, he will stay in office, my lord. The case is there, my lord, and one document is submitted by him, my lord. He is as the grade 4 employee, my lord, their signature. It was not annexed in the petition also, my lord. So no, that is not record. I have to give reply also that, my lord. So he will use the office, my lord. That will be a problem to the office.
But you say charge is already taken.
Yes,
isn't
my
it?
lord. Status quo, okay. Status quo so far.
So why are you so afraid?
No, is it his submission that there is a disciplinary proceeding pending against me that I cannot enter office? Then what is he saying actually?
Question is the one documents my senior friend submitted before this honorable court, which was not annexed to the writ petition. So I have to reply that on that also. So that should be come to with
No, not only that, you reply on everything.
Yes, ma'am.
Reply on everything which, according to you, should be replied, so that we can trash out this matter. That's what I'm saying. Because allegation, counter allegation, reply, all these things cannot go on like this. Court cannot settle the matter.
Yes, madam.
So it has to be on record.
Yes, madam.
As on today, we have the writ petition in those 2 cases.
And so far,
You-
this one
you-
of my, the letter is there, my lord.
You
This-
file your affidavit
Yes.
within a specified time,
My lord, this,
then
one of my letter
we'll
is
take a
there.
call.
My lord, one of my letters before this honorable court is there, that this interview will be held after screening committee. Second half of the January 2026, the interview, my lord.
All right, very good. So you have, there's no harm in saying status quo then.
So so far, my lord, the other status quo is required, my lord, this over financial is concerned, my lord. That is, my lord, it will be, because we cannot disburse anything, my lord, and we cannot, the university without the signature of the registrar. My lord. That will, for the university, my lord. So that may not be, lordship may fix, and after 10 days, I will file it for 7 days. Finally hard.
So that is why, as on today, we're not saying anything much. You file your returns. So that things don't get aggravated, we hold things back, status quo on today. How much, what difficulty will be there?
My lord, so far financial is concerned, we have to, we cannot operate bank account, my lord. University man. So the university is not running by the.
So that means you have not taken charge.
No, my lord,
Yes.
no, my lord, we have-
That
we-
is
no,
my-
no,
that is
no,
my
no,
statement,
no,
my lord.
When, my lord, this, the bank transaction, it takes time, my lord.
No, see, don't, saying no will not do, you
No,
see.
I understand.
There has to be some reasonable submission.
My lord, what happened, my lord? This
Keep on repeating, saying no, what doesn't make anything, doesn't make any sense.
Humble submission before his honorable court, my lord. So far, the official release from his the post, my lord, and another transaction with the bank. It takes another 1-2 days time, my lord. So bank, we have to submit a signature, everything, all this.
So you pursue that,
My lord, my submission
What-
is,
what should we do?
my lord, so far as the second writ petition is concerned, my lord, my submission is that, my lord, prima facie, my lord, it is an order ex facie illegal. Because they are going to replace me by an ad hoc. And that too disregarding the appointment order. The appointment order says it was by executive council. How come the VC is vested with the power to issue an order of release?
Status has a, PC has a power, man. Status.
My lord, may I kindly see, I have also read the statute, my lord, if I have understood a bit of it. No.
Where is the statute?
My lord, I am giving a copy of the statute to your lordship, my lord. It has to be on the approval of the executive council. Your lordship will kindly see.
Approval is taken, my lord.
Approval has taken is today morning.
Yes, my lord.
Yesterday there was no approval.
Yes, my lord.
If your lordship will kindly come to page 1891. Clause 4.2.24. Has your lordship got it, my lord? 1891. Statute, তুমি তো statute পড়াই আছে।
On it.
4.2.24.
Yes, read.
In the event of any temporary vacancy in the office of the registrar due to
No, just a minute. 4.2,
2.24.
oh, 24, okay, yes.
4.24.
In the event of any temporary vacancy in the office of the registrar due to her, his leave on ground of illness or any other exigency, the vice chancellor on the approval of the executive council may commit the charge of the office of the registry to any suitable officer, professor of the university for a temporary period. So yesterday you pass an order, where is the approval?
Yes, approval is there, my lord. This way, it's taken today itself. I've submitted before the court.
This 4.2.2.4 was invoked in giving you the charge.
Yes, but
Earlier.
yes. And this, and yesterday, if your lordship will kindly see what the order says the approval of the executive council will be taken tomorrow. That means will the VC now dictate the executive council that I have done something, you now ratify it?
My lord,
A ratification to an illegal order is without any consequence.
my lord, I've submitted the resolution of the court.
I have made a statement on my petition itself that they have taken a decision to ratify it today morning. How can you do some illegal act and get it ratified by a council?
My lord, it is already.
That will not validate, that will not validate the illegal act.
Yes, but it's, my lord,
So therefore, my lord, my submission is that this transaction on paper, whatever they might have done, my lord, that is only a symbolic thing. In reality, my lord, the charge is still with me, and there is a candid apprehension, my lord, from the respondent side that if the order is passed, then financial transaction will get affected. So in that case, my submission is that, my lord, this order of 25th 11 should be stayed.
No, my lord.
until your lordship finally decides the matter.
See, regarding your initial giving of the charge, this is as per the resolution adopted by the 15th Executive Council meeting.
Yes,
This is in terms of which provision?
that is, my lord, this is,
Is it the same provision, 4.2.2.4?
my lord, yes. That is in terms of 4.2.2.4, because EC will take the decision and thereafter it will be executed through the VC. It is not the other way around. So even if my appointment is to be interdicted now, my lord, it can be only by the, initiated by the EC.
No, my lord.
It cannot be done by the VC and thereafter he will seek an approval of the VC, EC for the purpose of ratification.
Lordship met on the annexure 4 of repression, my lord, order 27/2025. In pursuance of the resolution adopted by 15th Executive Council meeting on 26 June, so and so, the IIT, this Sekhar County Deputy Registrar, so and so is hereby appointed as an inserts for the temporary period with effect from 22nd till new then. There is no provision mentioned. Question is, when he was there, he is there, he could, it was done. The problem is only the inserts register problem. So question of new, not the appointment of new register, new register. Is it clear?
Of the act.
Yes.
Page 15 of the new writ petition.
Well, these cannot be in the contemplation, my lord, for the simple reason that the order is very clear. It is not an emergent situation as such that he can take something and ask for the ratification later. This is clearly outside his powers. And although it is generic in nature, my lord, it does not deal with the situation contemplated under 4.2.2, 4.2.24.
No, that thing is okay. Now regarding this mention of section 13, subsection 4 of the University Act of 2017, what is this?
No, he says that he has invoked this power. But if your lordship has to see
So-
that whether in such a situation this power can be invoked at all.
So let us see that act power. Where is that power? Provision.
Well, that is in the statute. Your lordship may kindly see this. This is the act. Clause 4. Well, my lord, your lordship will get it at page 4778.
Yes.
4778. If in the opinion of the Vice Chancellor an emergency has arisen, which requires immediate action to be taken, the Vice Chancellor shall take such actions as he deems necessary and shall report the same to the authority or committee, which in the ordinary course would have dealt with the matter. Provided that where any such action taken by the Vice Chancellor affects the services or emoluments of any person in the service of the university, such person shall be entitled to prefer within 30 days from the date on which he received notice of such action and appeal to Executive Council, whose decision shall be final. Can this be invoked at all in the case of a stopgap arrangement which has been made previously? And what is the opinion as regards the emergency arising in the case? Emergency is that since I have filed a writ petition before the court, so that is the emergency that I should be relieved of the duty.
My lord, this, the registrar will deal the case, my lord. This is the case, my lord. Registrar will deal the case, my lord. VC will not, my lord. So provision speaks, my lord, the registrar, my lord, the registrar, in every case, my lord, registrar, this the appropriate authority, institute gives the power to deal, contest the case or everything, my lord. So he, now how this, he will contest this case?
Well, it's a wonderful proposition. If it is to, if it is to be accepted, then in entirety, my lord, in that case, no registrar can file any case against the university at all.
That is the.
Can it be a situation like that?
Capacity is different.
It's a litigation at the personal level. It's
Personal
an individual capacity. How can he mix the two?
A man, he filed a case before, against the university. He is in search register, and he will supply everything on behalf of the respondent to his petition. How this will happen? Both sides are the same man. One is an insert register and one is a writ petitioner. This is the main thing before the honorable court. Only he is not, this main intention to only to.
Now, who will file the counter affidavit?
Well, the executive council is there, VC is there, they are the party respondents in the case.
VC, the status given the authority.
If the VC doesn't want to file a counter, my lord, it's his choice. Executive council is also a party to the case. Ultimately, my lord, the general power of the university vests in the executive council, not in the VC. And therefore, my lord, the 4.2.2 also says that it is on the approval of the executive council that the appointment or any temporary arrangement that has to be made.
Somebody files on behalf of the VC and normally it's the registrar, isn't it?
And my lord is.
Who will be the next officer in line on behalf of the university?
No, my
Well,
lord,
that is
my lord, this is new university, my lord. So, my lord, all the posts are not filled up, my lord. Even my lord, this the deputy registrar was filled up, my lord. The one registered joined him, he left and he joined in other place, my lord. One academic register is an academic register is given the search.
Then let the VC file. If you don't have so many posts. VC is there. He's taken a decision.
My lord, status give my lord the authority, the regulation, the government
No,
of Assam give the authority to.
Since the registrar has filed a case on his personal capacity, although he's officially as the in charge. So there might be some clash of interest.
My lord, I have submitted, there's an inquiry report, my lord. The inquiry report speaks, my lord,
That is your oral submission.
No, I have
That
instruction.
is why
Instruction is there, my lord.
your instruction is nothing to me,
Yes.
unless it is on record by way of an
Yes, my lord.
affidavit.
Yes, my lord. So, my lord,
It's only a loose paper.
yes, my lord, I understand, my lord.
Mr.
but-
Counsel, please understand,
Understand me.
the concept of accepting loose paper has been going on too long a time
Understand,
now.
understand, my lord.
There'll be a day in which we don't accept it anymore.
Understand, my lord.
It never used to be accepted.
Yes, my lord, but my learned friend, the place.
Well, there is an averment on oath supported by it. I have not just exchanged the paper across the board.
My contention also, my lord, he, according to my senior friend, my lord, 5% only received, my lord. He knows everything. This from his office, my lord.
All right, I have heard enough. I'm issuing notice and fixing a date on which date we'll try to consider the thing and dispose it of finally. Seeing the issues involved here. Heard. Mr. S. Datta, Lanet Senior Counsel, assisted by Ms. Aidas for the petitioner, who submits that by filing this writ petition, the petitioner has sought for a direction to the respondent authorities to redraw the provisional screening list by deleting the names of the late applicants who had not submitted their application for the post of registrar of the university before university, you write respondent university. As on the last date, that is 30/8/2025. And also for a direction to the respondent number 3 not to process, not to insist for the petitioner's past appointment orders indicating pay scale etc. So the learned senior counsel submits that the petitioner was made the in charge registrar of the respondent university pursuant to a resolution adopted by the 15th Executive Council, which held its meeting on 26/6/2025. And his appointment as in charge registrar is with effect from 2/7/2025 till the new registrar joins. Stop, he submits that since there were only 5 applicants as on the last date of submission of application, the number of candidates for the post in question should be restricted to 5 numbers only. In view of above, issue notice of motion returnable by any date,
My lord, 7th of December, my lord.
7th of December. No. 7 is Sunday.
7, my lord. Oh, sorry.
9th of December. Mr. S.K. Mehdi, learned standing counsel.
I'm for my lord, respond 2 and 3.
Rabindranath Tagore University accepts notice on behalf of respondent numbers.
My lord, 1, 2, my lord, all are my lord, office of my lord, respondent 2 is university, 3 is
No,
PC.
2, 3, 2 and 3.
And 4, my lord, the office of the PC, my lord, this is my lord, the office of the PC here of Rakhol. And then the next also, my lord, is number.
Just listen. What are you saying? Number 4 is one Rakhal Roy Chaudhary. Will accept notice?
I will accept,
Then-
but their notice will go to the office, PC, my lord, PR of my lord. What they are, my lord, the Rakhal Chaudhary, office of the vice chancellor. This is the what he is. There is no mention. Rakhal Chaudhary, my lord, office of the vice chancellor. Rabindranath.
Don't worry about that, okay?
This is my lord.
Accept notice on behalf of respondent numbers 2 and 3. While who appears? While Mr. A.R. Tahibildar, learned standing counsel,
Higher education.
higher education accepts notice on behalf of respondent number 1. Now, how will you serve this notice?
My lord, 4 to 9 will go by registered post.
My lord, earlier disposal, my lord, dusty service, my lord, maybe my lord, fund with me.
Dusty.
Dusty, I can do, my lord, but that is only an alternative mode. Let me first take it through the registry, my lord, the registered post. Thereafter, if necessary, my lord, your lordship can always.
No. Because
Or
of that-
otherwise, if your lordship permits, my lord, I can also take Dusty.
let it be Dusty at this stage also, because we are fixing a date. Petitioner to serve notice to the remaining respondents by way of Dusty.
Through the
the-
registry, my lord.
Through the registry of this court. And thereafter file an affidavit as proof of service. List on 9th of December. The respondent university shall file their affidavit in opposition on or before 5th of December.
Yes, my lord.
By serving a copy of the affidavit in opposition to the petitioner. And the petitioner may file rejoinder affidavit on or before 9th December. An attempt shall be made to dispose of this case finally on the next
Yes.
date fixed.
Till then, my
No,
lord,
no,
this
my lord, that-
status
my-
may be
humble
observed.
request from the university, my lord.
Hmm?
Till that, no, no interim, my lord. Because, my lord, this will suffer, university will suffer, my lord, this is a big organization, my lord, this nine,
Suffer how?
it will be disposed, my lord.
How will suffer?
We cannot, suffer, my lord, this, if, signature, my lord, is to, my lord, new signature is replaced before the, bank, my lord. So for transaction, my lord, register signature, my lord. So I humbly request, my lord, nine, my lord, the lordship will dispose of everything, my lord, you allow, everything will have. Go ahead, see, the one.
Having regard to the projection made by the petitioner, it is provided herein that till the next returnable date, status quo shall be maintained. Now, in the next writ petition,
Here also, my lord, lordship can post it together with the same kind of order.
definitely we'll post it together.
Yes, yes.
That is the intention. Art, Mr. S. Datta, Learned Senior Counsel, assisted by Ms. Aidas for the petitioner, who submits that after the filing of WPC number 6700 of 2025, there has been certain further developments in the matter
Number na jano.
by which,
Kaise matro.
no, in the matter, stop. He submits that White order dated 25/11/2025 the petitioner, who was serving as the in-charge registrar of the respondent university, has been replaced by another in-charge registrar, which is not permissible in law. Stop. He submits that the vice chancellor of the university cannot take such a step without the approval of the executive council as laid down in regulation regulation 4.2.2.4. This is a statute or regulation.
Well, this,
Whether it's a
this rule,
statute,
rule.
statute of the
Yes,
college.
these rules are, my lord. Rules and regulations. But here, my lord, this word, my lord, written, my lord, the illness or any other exigency, my lord. But here case is, my lord, court case is filed, my lord. So here, it will not applicable, in our case.
You say that on your affidavit.
And this is my
What cause?
submission. I am not, this is looking at.
Alage.
You write like this, not regulation, okay? As provided in clause 4.2.2.4 of the statutes of the university. Stop. He also submits that section 13(4) of the Rabindranath Tagore University Act, 2000, 17. Did I say 13-4? Okay. Is to be invoked only in an emergency, which requires immediate action to be taken by the Vice Chancellor. Stop. However, in the present case, there is no such emergency for invoking the said provision. And therefore, in order to replace the petitioner, the approval of the Executive Council of the university is necessary. Stop. He therefore submits that the impugn order dated 25/11/2025 will be set aside. Next para, in view of above issue notice of motion returnable by 9th of December. Mr. S.K. Mehdi, learned learned standing counsel for the university, accepts notice on behalf of respondent numbers 2 and 3. While Mr. M.R. Sorry, Mr. A.R. Tahibildar, learned standing counsel, higher education accepts notice on behalf of respondent number 1. Extra copies be served to them within 2 days. Petitioner to serve notice to respondent number 4 by way of plastic to the registry of this court, and thereafter file an affidavit as proof of, to show proof of service. List the matter on 9th December 2025 along with WPC number 6700. Until the next date of listing, parties are directed to maintain status quo.
Well, only my submission also recorded, madam, because I'm representing university, madam. So my lord is that is required, madam, because so far my lord is.
Next line, Mr. S.K. Mehdi, learned counsel for the respondent university, submits that no interim order may be passed because the function of the university itself would be jeopardized.
No, my lord, that is my lord. I'm mentioning this regulation, my lord. 4.2.4.8, my lord. Here required by this, my lord, registrar is required to defend the case, my lord. That is.
And that as per the impugn, as reflected in the impugn order dated 25/11/2025, under clause 4.2.4.8 of the statute, the registrar is required to represent the university in a court of law. To stop, it is for that reason that
My lord,
he has to be replaced in view of the litigation filed by him, although maybe in a private capacity. To stop, the said submission has been considered, but this court is of the considered view that in view of the grievances, in view of the issue raised by the petitioner, the objection raised by Mr. S.K. Mehdi is rejected.
Status quo, my lord, till that means. Status quo till that means.
That was there, you objected, so I recorded.
My lord, I have to answer the thing.
You have to answer, I know, that's why now you show that.
Yes.
For orders, I don't know.
What about this motion? There's one more. You call it now, let's finish. Yes, what is this?
May it please your lordship. In this case, my lord, the petitioner before lordship was participated in a selection process for the post of principal of Belsor Higher Secondary School. But the state selection board, my lord, approved my selection, and which will find at page 23, my lord. I am Jayanto Kumar Burman, my lord. Page 23. Page 24, my lord.
Just a minute.
Secondary division. My lord. My lord. My lord. My lord.
Then review was held. No, again, before that review, you preferred review petition.
My lord.
And during the pendency of the review petition, the rehearing was done,
My lord.
wherein you have been again selected.
My lord.
So that is your case.
My lord. My lord, what happened, my lord, in the
Then thereafter, what is to be done now?
my lord, pursuant to the my lord, first recommendation at page 24, I was appointed as principal, my lord.
Yes.
I was appointed as principal at page 25, my lord. On 3/3/2020.
Then
My lord, however, my lord, this honorable court, my lord, some facts were not presented before the honorable court, my lord. On wrong presumption, my lord, this order was passed at page 27. Against which, my lord, I sought for review. Lordship will find the direction in the earlier on the litigation, my lord, at page 47. Page 47. My appointment and selection was set aside. And the authority was directed to conduct the selection afresh on the basis of the earlier applications.
your appointment was set aside.
My lord. Then, my lord, I preferred the review. My lord, in the review, my lord, while issuing notice, the honorable review court was, my lord, at page 52, my lord.
Just a minute. You were not a party in that case.
I was a party in this case, my lord, in the earlier under litigation.
Link case is also there. How many writ petitions were there?
Two petitions, my lord.
Hmm?
Two petitions, my lord.
What were they for? One was for your, against your selection,
Against my selection,
and the other one?
other one also, my lord, against the selection by the writ petition at, my lord, WPC 2776. By this writ petition, he challenged my lord, appointment. The other writ petition, my lord, my lord, challenged the selection process. He challenged the selection process.
Process.
Yes, my lord. Both will take it up together, my lord.
Then outcome,
Outcome at page 47, my lord.
appointment set aside.
My lord.
Then
Then, my lord, I preferred the review, my lord. Review while issuing notice at page 50, my lord. At page 52, it is provided that in the event of any appointment is affected in respect of respondent number 6, the same should be subject to further orders that would pass in the matter upon hearing the respondent number 6 on his appearance in the matter.
who's respondent number
Respondent number
six?
6 is the writ petitioner in the, my lord, earlier in the litigation, my lord. And I was the review petitioner. In the meantime, my lord, an order was passed by the director at page
Respondent number 6 is the
writ
writ
petitioner,
petitioner.
Gangadhar Burman, my lord.
Review is by you.
My lord.
Then
By order at page 53, I was reverted back to the post of my lord assistant teacher.
Hmm.
The relevant person also will find at page 54. Page 54, my lord.
yes,
Second paragraph. Moreover, Sri Jayanta Kumar Burman is reverted back to the post of graduate teacher of so and so. Thereafter, my lord, on the basis of my review petition, as well as I also filed a representation before the authority while explaining all the details, my lord, which were suppressed by the my lord, writ petitioner in the other writ petition during the hearing. Those were obtained by the petitioner, my lord, through RTI. Those materials were, my lord, placed before the authority. Then a hearing was taken place. And outcome of the hearing is at page 57, my lord. I was again placed at serial number 1.
and who's the other person? What's his name?
Gangadhar Burman, my lord, he is placed at serial number 3, my lord.
There are two of you getting same marks, 16 marks.
Same marks. Because of age, my lord, I was placed at 1, my lord.
Okay. So,
My lord, I should have been appointed in view of these findings. Instead of appointing me in the same order, my lord,
yes,
at page 58, also will find, second paragraph, as such, Sri Jayanta Kumar Burman, first empanel candidate, is eligible for the post of regular principal of Belsor Higher Secondary School. But it is seen from the office record that a departmental proceeding is pending against Sri Jayanta Kumar Burman. Hence, the State Selection Board has decided to keep the result regarding selection of regular principal of Belsor Higher Secondary School, Nalbari, in seal cover till completion of the departmental proceeding. Also, will find the departmental proceeding. So,
So-
this
the seal cover has been opened.
no.
Then how do you know this?
My lord, this is the order from which, my lord, I came to know that I was the first empanel candidate.
So what remains now to keeping seal cover? We know who is who.
I don't know, my lord, why they have kept the only to deprive me
You
from
are,
the post.
you are
Because
at
I am
place at serial
retiring
number
on
1.
30th of November, my lord.
The
I am-
other petition places serial number 3. Everybody knows that. What is that seal cover?
My lord. My lord, I am retiring on 30th of November this month, my lord.
Okay, tell me about the departmental proceeding. What is that?
My lord, at page 66, this is the so cause, also you will find. And this so cause was issued on 3/7/2024. 3/7/2024.
Hmm.
And I was appointed as principal on 3/3/2020.
So cause for what?
So cause some anomalies they have detected, my lord, and I have been so caused, and accordingly I have also filed reply. Thereafter, my lord, no action has been taken on the departmental proceeding. Still date, my lord, no inquiry officer has been appointed, no presenting officer has been appointed, no inquiry has been conducted. More than 2 years have passed. So, my lord, for outcome of the departmental proceeding, if I wait, my lord, then my lord, what will happen to my post of principal, my lord?
When are you?
I am retiring on 30th of this month, my lord.
30.
Yes, my lord.
So what can be done now?
My case is that, my lord, this departmental proceeding is after the selection and appointment of the principal of the school. This departmental proceeding was initiated. Even if I am punished in the departmental proceeding, I will follow the consequences. My contention is that, my lord, this departmental proceeding cannot come on the way of the appointment of principal, because it was subsequent event, my lord. This selection was made, my lord, in the year 2019, and I was appointed in the year 2020. So
And
my-
your appointment was set aside by this court also?
Yes, my lord.
Then-
That was set aside, and my lord,
Your appointment was set aside by this court
yes, my lord.
by judgment order dated 6/9/24.
6/9/2024.
Before that, show cause was given to you.
No so cause was issued, my lord.
No, show cause is dated 3/7/24.
This is the so cause, my lord, regarding a different aspect, my lord, regarding, my lord, supplying of uniform in the school while I was working as a principal. While I was working as a principal, regarding supply of, my lord, uniform to the students, my lord, the managing committee chairman, my lord, he did not sign in the my lord, for which, my lord, this uniforms could not be obtained by the petitioner.
All right, whatever the case may be,
My lord, my lord.
show cause was given to you on 3rd July. And the writ petition of that private respondent
Yes, my lord,
was disposed of on 6/9/24
my lord,
by setting aside your appointment.
my lord. Against which, my lord, I prepared the review, bringing all the my lord, facts which were not
Review is
correct,
not disposed.
my lord.
Review is not
Review
disposed.
is disposed, my lord.
How?
In the of the findings in the order, my lord. Review lawsuit file at page 59. That has been disposed, my lord.
How is it disposed? How was it disposed?
Uh, May I read the order, my lord? Page 60, my lord.
Two eleven. What is 211?
211 order is the, my lord, new findings, my lord.
So you withdrew the review petition, that's why. Because of 211.
Yes, my lord. And
So-
thereafter, my lord, I was granted liberty to approach the authority, my lord, in the review petition. While closing the review petition, my lord, I filed a representation at page 63. Page 63.
So what relief are you seeking now?
My case is that, my lord, I want to retire as a principal, as I was a selected candidate, my lord, as my name has been approved by the authority. Because of the, my lord, departmental proceeding, which was initiated after my initial selection and appointment, I may not be deprived from the post, my lord, before my retirement, my lord. That is the limited grievance, my lord, and if that is allowed, my lord, if the authority is allowed to keep the result in seal cover and by not appointing me, that will also affect my pension also, my lord. Departmental proceeding, I will face the consequences, whatever is done by the authority, my lord, during my lord inquiry and all, my lord. But if I am deprived from the post now, my lord, that will be amount to, my lord, punishing me without concluding the DP, my lord. Yes, yes, my lord. Yes, my lord. So my lord, it will relate back to the initial selection and appointment, my lord. Because court did not say that fresh advertisement should be made on the basis of the application filed earlier, my lord. It was directed to be redone. Appointment is on 3/3/2020, my lord, page 25.
Here, they served the copy in our office and moreover, they have not informed us regarding the production list matter, my lord. So, my lord, at this stage, my lord, notice may be issued. Regarding promotion, my lord, after notice, my lord, our reply will be there, my lord. And I will obtain the necessary instruction regarding that, my lord. But at this stage, my lord, it is not possible as because I have not actually gone through this matter also, my lord. Just now I received the copy from this court, my lord.
My lord, in the meantime, lordship may direct the authority, my lord, to appoint the petitioner, my lord, subject to outcome of the writ petition, my lord.
No.
Because, my lord, before my retirement, my lord, if I am not appointed, my lord, my pension will be affected, my lord. That is the only apprehension. Because I was appointed as a principal of the school, my lord, on regular basis. Thereafter, a selection, my lord, challenge was made on the selection, on the basis of the
Yes.
my lord, on the basis of direction of the Honorable Court, my lord, the process has been redone, and I have been again, my lord, found to be the candidate at first in the selection list, my lord, in the first position. So, my lord, there is nothing, no impediment in
No,
my
no
appointment, my
impediment.
lord. But departmental proceeding, my lord, lordship has seen, my lord, 2.5 years, they have not done anything in the departmental proceeding. 2.5 years. Except, my lord, issuing the show cause notice, they have not done anything. They have not proceeded with the departmental proceeding. After receiving my reply, they may even, my lord, drop the proceeding also, my lord. Because 2.5 years, my lord, they have not done anything.
That much.
That-
Heard Mr. Ayed Saikia, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner seeks for a direction to the respondent authorities to appoint him as the principal of
Belsor High Secondary School.
which school?
Belsor High Secondary School, my lord.
Belsor.
Nalbari
Be-
district.
Where do we get that?
In the synopsis itself, my lord, second line, my lord, Belsor High Secondary School, my lord. On page 25 also, also you'll find I was appointed earlier, my lord.
Okay. Belsor Higher Secondary School in the district of Nalbari. In terms of the
Page 57, my lord.
what is 57? This is a finding?
The order.
Finding, loss will find at page 58, my lord.
Finding by whom?
This is by the State Selection Board, my lord. It has been issued by the Director of Secondary Education, Assam.
in terms of the finding of the State Selection Board.
The person placed at serial number 2 has already retired, my lord. The first paragraph of page 58, my lord.
Issued in the form of order dated 2/11/2025 by the Director of Secondary Education, Assam. Stop, next paragraph. The Learned Council submits that the petitioner was appointed as the principal of the state school on
On 3/3/2020, my lord.
3/3/2020, but aggrieved with his appointment. Any private respondent here?
No, my lord. One Gangadhar Burman, my lord.
One Sri Gangadhar Burman, file WPC number 2776 of 2020. Full stop. The writ petition was disposed of.
Page 30.
White common order dated. White common judgment and order dated 6/9/2024. Along with WPC number 6004 of 2022. Filed by the same person. By interfering with the appointment of the petitioner herein and directing the State Selection Committee the School Selection Committee to carry out a review selection stop aggrieved with the same, the present writ petition filed review petition
201 of 2020.
number 201 of 2025. But during the pendency of the review petition, order dated 2/11/2025 came to be passed in favor of the petitioner. And so the review petition was withdrawn by the writ petitioner. Stop. However, while the order dated 2/11/2025, it was stated that although the petitioner was found to be eligible for being posted as the regular principal of the school, but in view of the departmental proceeding pending against him, the result of the selection be kept in seal cover. Stop. According to Mr. Ayat Saikia, the Ashoka's notice was issued to the petitioner on 3/7/2024, and to which the petitioner replied on 1/8/2024. denying the allegation. Allegations, sir. Stop. He submits that apart from that, no further steps has been taken by the respondent authorities. And therefore, the petitioner should be appointed as the principal of the school. Pending finalization of the departmental proceeding. In view of the fact that he is due to retire from service on superannuation on
30/11/2025.
30/11/2025. Next para. In view of above, issue notice of motion. Returnable by 3 weeks. Mr. U Sharma, Learned Standing Counsel. Secretary Education. Accepts notice on behalf of all the respondents. Extra copies be furnished to him within 2 days. Next para, having regard to the projection made by the petitioner, it is observed herein that superannuation of the petitioner no, retirement of the petitioner on superannuation will not be a bar for him to get the benefit of his entitlement to be the principal of the school. And sir, in the event of the writ petition being concluded, writ petition as well as the departmental proceedings being concluded in his favor.
My lord, one more prayer, my lord. My lord, before my retirement, let the authority, my lord, decide my representation at phase, my lord, 63.
He is retiring day after tomorrow.
Yes. 2
There's
days
no
are left.
time. There's no time.
3 days are left, my lord.
There's no time.
3 days, 3 working days are left.
My lord.
Phase 63, my lord. I have also assured that, my lord, I will not do any, my lord, financial transaction. I just want to hold the chair before my retirement, my lord. This is the,
You may want to, but what to do? Cannot go that way.
that will no, my lord. Even if I am appointed, my lord, no one will be affected, my lord. No one will be.
No, practically, see, there's only 1 day.
3 working days, my lord. 3 working days, my lord. Saturday also,
Saturday is a working day?
my lord.
Mr. Sharma,
Fifth Saturday, my lord. Fifth
Sa-
Saturday,
Saturday is a working day.
fifth Saturday, my lord. This Saturday, fifth.
My lord, disposal of representation is to maintain to some extent procedure is required, my lord, regarding hearing may be taken place, my lord. So, my lord, it's takes some time, my lord. So, my lord, in a short time, my lord, disposal is not possible, my lord. So, at this stage, my lord, notice is, my lord, best, my lord.
My lord, even if I am appointed, my lord, as principal before my retirement, my lord, no one will be affected, my lord.
No.
Only for the purpose of, my lord, his satisfaction, my lord, as he is a selected candidate, my lord. And he served as principal for, my lord, 4 years. 5 years.
One
my
more line, since the petitioner is said to be due to retire on superannuation on 30/11/2025. The respondent authorities will be at liberty to consider and dispose of his pending representation before his retirement. I'll give them liberty, I'll not say, wait, 2 days will be difficult.
3 working days, my lord. Saturday is a working day.
Anyway, you pursue the matter, they might consider,
My lord.
right?
Obliged.
Copy to the
So what?
That is becoming infructuous, man. I can forget it.
Mr. U. Sharma, learned counsel for the respondent department submits that the matter has become infructuous. Now, however, since no one appears for the petitioner, let the matter be listed again after a week on a date to be fixed by the registry. Yes.
Some instruction.
Lordship, I've just placed the instructions today. It was given to me, Your Lordship. This man, when I report this, certain documents were missing. Can I आपको कितनी documents missing? Post to place okay.
Okay, some additional documents were required, remaining documents.
Lordship.
Now, that is one thing.
Lordship.
After documents are received, then what is the other process?
Lordship, because
Where else will you take us?
because these school these are all upgraded schools, Your Lordship. So there are no posts of principal posts. So we have to create those posts. So we had
You don't want to create the post, it seems.
Lordship.
Half-heartedly or quarter-heartedly? It's been quite some time.
Quite
We've been
some
asking
time,
you
Lordship. Yes, Your Lordship.
when. And yet you come again with saying that
Again, Your Lordship.
some more remaining documents
Yes,
required.
yes, Your Lordship.
So tomorrow that remaining documents is given.
Lordship.
Thereafter, what happens? Again, you will go to some other department Gave us fund or something like that, finance, who else?
Finance.
So the very purpose of the filing a review petition was something else. Now thinking that at least very soon something will be done, we thought we'll keep this thing pending. But if this is the manner in which things are going to progress, I don't know,
Lordship,
there'll be no end.
in 2022, on a statement made by the respondent that within a week something will happen. The Lordship had modified the order and gave the inspector of schools the charge. Now for the 3 years he have been continuing their judgments. They are annexed to this petition which was not brought to your Lordship's notice at the time of hearing. That a in charge has also got to have the required qualification as per the regular, and there is therefore Lordship, till new post is created, Lordship, if I may be allowed to hold the charge, Lordship, that is my
Okay.
prayer.
Who is for the other side? Apart from Ms. Musari,
Okay, BTC is there.
BTC. No, what about that person who's holding the charge?
Also, he's the inspector. of
Oh, that's the
schools.
inspector.
Inspector.
Okay.
And Lordship, we have no problem if he is made, if the person petitioner is made the in charge principal, your Lordship, but there are no posts, your Lordship. That is the reason why your Lordship had given direction that the inspector of schools will be will be the in charge principal, your Lordship, for the administration and for the other purposes of the school. There are no posts, your Lordship.
So you give him charge then. What to do? What was the decision you had relied upon?
Yes, Lordship, page 124. 125 it operates. Now Lordship, para 5 of the here the DC was made in charge. As per law, an incumbent who is duly qualified and eligible alone can allowed to hold a post. Further, as laid down by the court in Jagannath Pegu, reported 2000, it had been held that even in order to a in charge principal of an education institution, the incumbent concerned must satisfy the educational qualification and other eligibility as may be prescribed for the post of principal. Accordingly, it is considered even in order to in charge principal, the government section Mahavidyalaya, the person concerned who is made the in charge would have to satisfy the required educational qualification that are prescribed for the post of principal.
Okay, just a minute. Where is this Jagannath Pegu's case?
Lordship,
Single
it's,
bench,
it's para 2007 3 GLT 389.
single bench.
It's a single bench, Lordship, para 10. Lordship, I have gone through it. It's judgment of Justice Amitav Roy. Para 10, this aspect is being dealt with in para 10, Lordship. And there are other judgment also which has followed the judgment continuously.
Any judgment with the larger strength, larger bench?
Lordship, if Lordship fixes it tomorrow, I can bring it. There are Lordship, in fact, division bench.
Because ordinarily,
Lordship,
the bench of
without going to the law, Lordship, what I require is that till the post is created, I may be allowed to.
So here the BTC's views will be required, your Lordship.
I understand that, but what about the writ petition? This order was passed in the IA. What has happened to the writ petition?
Now that this review has been coming, the review writ petition has been retaken, Lordship, now. It has
Okay,
it
but
will
what
come.
has happened to it? Is it still pending?
It is pending, Lordship. I have to.
You are not there in that case.
I was not there in the writ petition.
Problem is this bench is not sitting tomorrow.
Any day.
We'll have to go. They'll have to come up after 2 weeks.
Okay, Lordship.
You bring out the judgments, we'll see. Ms. D. Musari, learned counsel for the
Secondary education.
secondary education, submits that as per the instructions received by her, the process for requisitioning of complete documents is still in progress. And therefore, she has been instructed to seek some more time from the court. To undertake and complete the exercise of creation oblique upgradation of post of headmasters oblique principals of and vice principals of newly upgraded higher secondary schools. Next, para, the review sought for in the instant review petition is to the order passed by this court in IAC number 3703 of 2019. I'm sorry, not that.
Page
Passed
14.
in, not that. Passed in page,
Page 14.
passed in IAC number 1594 of 2021 on 27/9/2022. Directing the inspector of schools concerned, under which jurisdiction the school is situated, to act as in charge of the principal of the school. Full stop. The review petitioner contends that he is the senior most teacher and is eligible to be considered and given the charge of the principal. Full stop. Further, as the inspector of schools, to be in charge of the school is required to have the essential qualification as well. The review petitioner is the better option. Next para, in view of above, is the matter. Again on so and so. We'll fix the date. Here for BTC,
Lordship, on the next date, Lordship may dispose it of, will obtain our instruction. Lordship can dispose it.
not 8th. No. It has to be in the last third week. Not, Steve. 16 of August.
Deep.
Obliged to me.
May, my lord, the petitioner has challenged the my lord impugned order that your lordship will find at page 31. This is my lord, second round litigation filed by the my lord petitioner. Yes. Now petitioner has been provincialized in the year 2021, but his salary has not been my lord paid.
due to the pendency of the writ petition,
No,
which has
Mr.
been
Mandal.
disposed, my lord.
Why is it listed today for orders?
But service has been, my lord, completed. We have filed additional affidavit with effect to the respondent, private respondents, my lord.
Private respondent number?
Private respondent number. 8 and, my lord, 10. 8 and 10. It's
What about 12 SSA?
12. Yes. SSA has been, my lord, furnished and published, my lord, by order dated.
Who has filed affidavit so far?
But none has filed affidavit, my lord. We have filed additional affidavit with regard to the service report upon respondent number 8 and 10. So far, the, my lord, respondent number 12 is concerned by order dated, my lord, 8/4/2025. The respondent number 12 is implemented as party respondent.
Where's your amended cost title?
My lord.
Amended OKCA.
Yes. Amended cost title.
What is your claim? Your
Amended
claim,
cost title, my lord.
your claim, prayer.
Prayer. Yes. Prayer, my lord.
What is the relief you are seeking for, Mr. Mandal?
Yes, my lord, prayer, my lord, lordship will find at page 12, my lord. Page 12.
Please write down. Claim made in the writ petition by the petitioner is for payment of arrear and current salary with effect from 1/1/2021. So, Mr. M.U. Mandal, learned counsel appears for the petitioner. However, none appears for the respondents. As a last chance, 3 weeks' time is granted. If the affidavit is not filed, those petitions shall be considered and disposed of on the basis of materials available on record. List again on so itself.
12. Developers.
Please, your lordship. The revision petition has been filed for clarification of a observation
Revision or review petition?
of the order dated, my lord, the
You are filing review or revision?
review, my lord.
Then why did you say revision?
No, my lord, review, my lord. I filed the review application.
I heard revision, that's why.
The review application, my lord. Lord, the page 16, my lord. The issue is, my lord,
The petitioner was placed under suspension with effect from the date of arrest. Thereafter, my lord, I have filed a writ petition challenging the suspension order. And that order, your lordship was pleased to revoke it. And thereafter, I was joined. But my lord, the page 16, my lord, while my lord revoking the suspension, my lord, lordship has observed, my lord, page 16, my lord.
Yes.
Page 16, my lord, paragraph 7. The petitioner, as can be seen, has been suspended since so and so, and in the absence of any review made by the competent authority in terms of the decision of the apex court as referred to herein above, the same cannot continue in perpetuating. Accordingly, the respondents are directed to reinstate the petitioner back into service immediately. However, it is observed that since the departmental proceeding has been initiated against the petitioner and the same should be brought to its logical conclusion as expeditiously as possible, it is needless to state herein that the notification dated so and so suspending the petitioner is hereby set aside. It is, however, provided herein that, my lord, I am aggrieved by this, my lord. It is, however, provided herein that the petitioner's entitlement is restricted to the amount of subsistence allowance drawn by him.
So
My
if
lord,
you are aggrieved by it,
my lord,
why review? Why not appeal?
No, my lord. Subsequent to that, my lord, my lord, may kindly turn page number 17, my lord.
17.
Yes.
What is there in 17?
My lord, this is the notification, my lord, by which, my lord, I was reinstated, my lord.
Yes.
My lord, it says, my lord, as per order of the Honorable Guwahati High Court dated so and so, passed in so and so, the suspension order number so and so in respect of so and so, office of the so and so is hereby revoked with immediate effect. And the period of suspension, my lord, this is important, my lord, the period of suspension shall be treated as period on duty for all purpose of service and pension benefits. However, his entitlement is restricted to the amount of subsistence allowance drawn by him. My lord, already, my lord, the authority has, when my lord, suspension was revoked, my lord, the period of suspension has already been treated as a period on duty, my lord, for all purpose of service and pension benefits. But due to the, my lord, observation of your lordship in the last line, my lord, subsequently, I was not paid the, my lord, that area, my lord, salary, my lord, area part. My lord, I have made the representation, page 19 and 20, my lord. Page 19, my lord, with reference to the subject cited above, I have the honor to inform you that I have been debarred from getting subsistence allowance with effect from so and so to March so and so at a 50% and with effect from 15 March so and so to May 2075%. Earlier, it was reported that due to not having in budget provision, area bill was not prepared. For this reason, I request you to kindly my pending payments in current financial budget session. I therefore request to take kind necessary action as early as possible. Similarly, I have made another representation on 710, my lord, but I have been verbally, my lord, informed, my lord, due to this, my lord, observation, my lord, it is, however, provided herein that a petitioner's entitlement is restricted to the amount of subsistence allowance. My lord, I was not paid, my lord.
What happened to the departmental proceedings?
My lord?
Departmental proceedings?
My lord, departmental proceeding is still pending, my lord.
Still pending?
Yes. Because, my lord, in the departmental proceeding, first they have submitted a report, my lord, and subsequently, my lord, they have submitted another second report, my lord. So, challenging that second report, my lord, one petition was referred by our side, and the proceeding was, my lord, stayed, my lord.
Who's there for the first other side?
And it's a PHE, my lord, Public Health Engineering Department, my lord.
Issue notice.
Hello?
Issue notice. Heard, Mr.
M. Datta, my lord.
M. Datta, learned counsel for the petitioner.
The earlier occasion they appeared, my lord.
There's no record.
Last order.
Submits that by filing this review petition, the petitioner seeks review of the order dated 12/9/2024. Insofar as a restriction has been placed with regard to the entitlement of the petitioner on the on the amount of subsistence allowance already drawn by him. So the learned counsel submits that the petitioner was reinstated back into service from the suspension, and the suspension period as on duty for all purpose, but for the order passed by this court,
That observation, my lord.
but for the observation passed by this court, subsistence allowance has been restricted to what has already been drawn by him. You notice petitioner to serve notice to who's the respondent?
Public health engineering, my lord.
Standing counsel,
Yes.
PhD department.
Yes, yes.
You write like this: petitioner to serve notice to the respondents through the standing counsel, PhD department. And thereafter to submit the acknowledgement received before the registry as token of service. But they have already received here.
My lord, they have received, my lord. We have already served it.
Let's rewrite again. In view of above, issue notice returnable by 17th of December.
Yeah, my lord, R. Gogoi was appearing, my lord.
Who is the standing counsel now, PhD?
No, R. Gogoi, D. Gogoi, my lord. R. Gogoi.
Petitioner to serve notice to the respondents through their standing counsel, Mr. R. Gogoi, and submit the acknowledgement of the notice to the registry.
My lord, R. Gogoi.
R. Gogoi.
Service is complete, Lord.
Melus, please. Service is completed.
Okay, upon perusal of the Lavazima Court's order dated 7/11/2025, notice is accepted to be complete upon respondent numbers 4 and 5. Anyone appearing? 4 and 5? No one. 4 and 5. Office, since no one appears for respondent number 4 and 5 today, office to list the matter for admission after 2 weeks.
Date, can a date maybe fixed, Lordship?
Office complete.
2 weeks. Order date to be fixed by the registry.
All right.
May I please, your lordship? Lordship, service upon respondent number 4 is complete.
Okay, similar order, huh? You just write respondent number 4. Earlier it was 4 and 5, I think. This will be number 4.
Lordship, matters may be fixed next week as salary has not been paid since 2021.
It'll come up after 2 weeks. All right. Yes. We'll see.
Yes, Lordship.
Hmm. I think we have a date for the rest of the matters. Rest of the matters will be taken up on a convenient date. Okay.
Should item number 19, Lordship, can it be fixed on any date or the next one? Should place some urgency in the matter, Lordship.
Anyway, you get the dates from the court master. Okay. She'll look into it.
Nineteen to 0.